All right, good morning and welcome to the Nevada State Board of Pharmacy July 2025 meeting. Today is Wednesday, July 16th, and our meeting will now come to order. My name is Helen Clark and I'll be the presiding officer. We'll start with the Board of Pharmacy mission statement. In regulating the practice of pharmacy, the Nevada State Board of Pharmacy has a duty to carry out and enforce the provisions of Nevada law to protect the health, safety, and welfare of the public. Next, we'll do our roll call. Mr. Adam Porat.
Here.
Mr. Richard Tomaso.
Here.
Ms. Crystal Freitas.
Here.
Ms. Jay Jacobo.
Present.
Ms. Shanice Taylor.
Present.
Ms. Anna Carr.
Present.
We have all members present. Mr. Weiss, any announcements?
Good morning, Madam President. Good morning, public. As usual, this meeting will be run in compliance with Nevada open meeting law. From time to time, there'll be people doing testimony and giving witness on Zoom. For the board members, the television's in front of you for that. For the general public, it'll be out there. I'll remind the board members that please in the discipline hearings, identify yourself for the record if you can, if you're going to make a statement, so that we can pick that up for the record. And we do have one previous board member in the audience who's hiding behind the television for me, Jody Lewis. So welcome back, Jody, for that. Appreciate you coming to the meeting. Some things have been continued. We'll just deal with those as we go through the meeting, and I'll turn it back over to
Great, thank you, Mr. Weiss. As our next order of business, the board will open up the floor for any public comment. If we have anyone in the room who wishes to make a public comment, I ask that you come forward now, or if we have anyone online who wishes to make a public comment, please feel free to raise your hand on Zoom. Let us know through the chat function or press *9 or *6 to have your line.
not seeing anyone right now, Madam President.
And I don't see anyone in the room coming over. So with that, we'll close the period for public comment for now. There will be another opportunity at the end of the day for public comment as well. So with that, the next order of business is the approval of the meeting minutes from our June 2025 meeting. Board members, any discussion on the minutes?
No questions or discussions on the minutes, unless you did. I would move that we approve the minutes from the previous meeting.
Okay, we have a motion by Mr. Kobo, a second by Mr. Porat. Any further discussion? Okay, hearing none. All those in favor? Aye.
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 Any opposed? Okay, the meeting minutes have now been approved, and next we'll move on to the consent agenda. Board members, any questions or comments on the consent agenda? I took a look and I do not have any concerns or comments.
Crystal Freitas, I would move we approve the consent agenda as presented here.
Second.
Okay, we have a motion by Ms. Freitas, a second by Mr. Kobo. Any further discussion? Okay, all those in favor?
Aye.
Aye.
Any opposed? Okay, motion passes. All right, with that, we'll go ahead and move into our first agenda item.
Madam President, I want to make one more announcement. I'm sorry that I make a mistake. And I would do it in my report, but I'd just like to do it at the front so that all the public can hear it, because I'm not sure they're always listening to my report. So as of yesterday, we have posted, and it's live right now on our website under the meetings tab, the previous meetings videos. So that's going to be live moving forward as long as we hold the technology together. So the requests for audio and all the other things that we get from time to time can still happen. We'll have the audio, but we may route them to that. So just for the public, if they want to see a previous meeting, it'll be available on the website and they can just go view it themselves through YouTube. Thanks.
Excellent, thank you. All right, so with that, we'll go on to agenda item 5F and 5G. That's for CVS Pharmacy 17244 and Kimberly Kirsten. So if we could have representatives come forward. Good morning.
Good morning.
What else be joining you today?
I believe that I don't represent her, but Ms. Kirsten is on this remote.
Hi, I'm here. Can you hear me?
Yes, we can hear you. Okay, I'm gonna have you both state your name and titles for the record, and then I'll swear you both in together.
Good morning, Brian Convery. I'm Senior Legal Counsel, CVS Health. I'm here as a representative of CVS 17244.
Madam President, I'm sorry. I missed my window for recusal.
Never too late.
All right, and then Ms. Kirsten.
Yeah, Kimberly Kirsten. I'm a pharmacy manager at CVS store number 17244.
And if I could have you both join me in raising your hands, and then I'll need a verbal affirmation from each of you. Swear that the testimony that you're about to provide will be both truthful and complete.
I did.
I do.
Great, thank you so much. Mr. Hand.
Brett Camp for the record, prosecuting this matter on behalf of the state. This is case number 23-174-S. Respondent CVS Pharmacy 17244, pharmacy license PH 02188, and respondent registered pharmacist Kimberly Karsten, certificate of registration 20889. Charging document appears beginning on page 2648 of the board book. And we do have a proposed stipulation for your consideration and possible approval today that appears beginning on page 2658 of the board book. Ms. Kirsten filed an answer and notice of defense on her behalf, which appears beginning on page 2674, and CVS Pharmacy is entering into the proposed stipulation in lieu of filing an answer. So by way of brief background, this is a case involving misfilled prescription. Respondent Kirsten was responsible for the erroneously filled and dispensed prescription. And the error in the prescription arose from an erroneous direction to take a incorrect dosage. Therefore, and in addition to that, Ms. Kirsten failed to provide medication counseling to the patient, Aero's father. I believe the patient was a minor when the prescription was dispensed. And so as we propose, consistent with similar violations, Ms. Kirsten would pay a fine of $1,500 and pay $500 to partially reimburse the board for recoverable attorney's fees and costs. And CVS Pharmacy would pay a fine of $3,000 and pay $1,000 to partially reimburse the board for recoverable attorney's fees and costs. Those fines and fees would be due and payable by September 1st of this year. So unless there are further questions, this is the stipulation that we're presenting for your consideration and possible approval this morning.
Thank you, Mr. Hand. Mr. Convery, I'll start with you. Did you want to add or make additional comments?
I'd be happy to answer any questions, Ms. Park. I don't have anything additional to add. To thank Mr. Camp for his courtesies and his cooperation in getting to a settlement or a post-settlement. And I would ask the board to accept the settlement.
And then I'd like to give Ms. Kirsten an opportunity to comment as well. Ms. Kirsten, did you want to share anything with the board?
Yeah, I do want to say I apologize for this mistake. It's something that I think about every day when I practice. I think I've made a lot of changes since that day when this happened a couple of years ago to ensure that something like this never happens again. I'm deeply regretful of the entire situation, and I feel like it's been a huge learning lesson for me. And I've been working every day to become a better pharmacist and help my community and just avoid a mistake like this ever happening again.
So Ms. Kirsten, this is Helen Park, and I'm just curious about the circumstances that led to the error. In your pharmacy, is it a high volume pharmacy?
We are a high volume Target store, yes. So we are one of the busiest Target stores in Las Vegas. At that time of year, we were very busy in the summertime, and we were a little bit short-staffed around that time. And I think that could have contributed to the error.
Ms. Kirsten, this is Crystal Freitas. Just a question for you. What kind of changes, you said you made changes to your practice. What kind of changes and steps do you take now to prevent an error like this?
Yeah, so I triple check the any prescriptions that are for reconstitution, or especially for pediatric patients. I mean, I really triple check my math and make sure everything's like very accurate. My technicians have been very much trained to know that they are not to offer counseling. They send them to the consultation window. If anything is new, a new medication change, and then the parent or the patient can decline counseling to me, or I can provide counseling to them. I just make sure that I'm counseling every patient who gets a reconstituted medication and any other prescription medication that's new. There's just been a lot of retraining and a lot of extra efforts on my part to really avoid something like this happening again.
Okay, thank you.
Kirsten, this is Helen Clark again. Were you the only pharmacist working at that time?
Yes.
And then, did you have, it looks like Evelyn Bustos was your technician? Was there
Yes.
more than one technician at the time?
There was a Shelley Weber and Emmeline Bustos. Yes.
And you had mentioned that it was a very busy time of year. Felt that staffing may have impacted. Has the staffing improved or changed since then?
Yes, I think it has. I try to make my schedules in a way where I feel as I have as most technicians as I can have. So I feel like I can take extra measures to double check everything and not feel so short-staffed.
Thank you. Board members, any additional questions from Mr. Convery or Ms. Kirsten?
Yeah, Adam Porth for the record. Ms. Kirsten, just curious in this particular prescription, if you recall, with the erroneous directions, was the quantity of the medication adjusted to, it would seem it would require multiple bottles to fill the entire quantity of the erroneous direction? Was that filled for multiple bottles, or was it just the directions were wrong and the one bottle was dispensed?
The one bottle was dispensed and the directions were wrong.
Got it. Thank you.
Kirsten, my name is Dick Tomaso. I'm not a pharmacist, I'm a public member of the board. And I just want to clarify something for me. The circumstances on this bill. The technician typed out the prescription wrong, and you read what the technician typed out, or you read the prescription yourself wrong. Could you give me the circumstances and how it took place?
So it was, I can't remember if it was a transfer from another CVS, and it was typed in by the technician Emmeline Bustos, and it was sent over to me in data entry. I didn't catch the decimal error. I didn't catch the error in verification. So it was dispensed to the patient. It was reconstituted. I reconstituted, dispensed, give it to the patient. The parent declined counseling to the technician who was helping the parent. So I never counseled the patient or the parent.
Yeah.
And that's what I remember.
How could you have caught the decimal error? Were you looking at the prescription yourself? You looked at the prescription, you saw it was 1.3 or whatever it was, 1.8, and you put in, and you missed the decimal?
I missed the decimal, not the decimal point. Yeah, I didn't type it myself, and miss that also. I just missed the technician with the wrong decimal, leading to the wrong amount in the directions.
All right, so just to clarify in my mind, the technician put in 18. And you just read the 18. You didn't read the 1.8, is that right?
Yeah, I didn't catch that it was missing the decimal because it was supposed to be 1.8.
Well, how could you have caught it? Well, what should you have done differently?
I could have slowed down. I mean, I think I was just looking at it too fast. Yeah, I mean, on one side of the screen there was a decimal, on the other side there wasn't, so I missed that.
Okay, but you filled the prescription though, right?
Yes.
Okay, thank you.
Any other questions for Ms. Kirsten or Mr. Convery? I guess, Ms. Kirsten, just you're in agreement with the stipulation as presented?
Yes.
Right, if there are no other questions, I would feel comfortable moving forward with this two stipulations as written.
No other questions. Crystal Freitas, for the record, I'd move we approve stipulation as presented in the matter of CVS Pharmacy 17244 and Kimberly Kirsten.
Shanice Taylor, I second.
Madam President, before, I think Yen had just one quick question to clarify the record, and it's on me, and I should have raised her hand, but we didn't see her, so. Dr. Long, if you wanna go ahead, still no motion, voted on yet.
Yes, sorry, I apologize. I do have one question for the respondent, CVS, as well as the pharmacist. It was mentioned in paragraph 8 of the accusation that in the course of correcting the error, the pharmaceutical technician Shelley Weber delete the records for prescription number 241056. My question to either respondent is, is this something that the pharmacy technician shouldn't have been able to do, and whether or not this issue with being able to delete prescription records have been rectified?
Sure, no, the prescription, although the allegation says it was deleted, the information was not deleted from our overall server system. It was deleted at the store level. And when I believe the inspector came in to ask questions, it could not be recovered at the store level. So that was, the technician did something wrong there, but it was not deleted from our system. We did recover, and we were able to provide, I believe, the inspector with all of the information pertaining to the prescription, including the prescription copy.
Okay, great, thank you. That was my only question.
Ms. Kirsten, do you know why the technician attempted to delete the record?
She said it was an accident. I wasn't there that day when the parent came in, and the error was rectified. So it was in processing the like returning the prescription and trying to go through the process, she accidentally deleted it at the store level. It's not something that I would ever tell my technicians to do, nor are they ever trained to do that. It was just a mistake that she made.
Okay, thank you. All right, so I think we have a motion by Ms. Freitas, a second by, I'll give to Dr. Taylor. And do we have any further discussion? Okay, hearing none, all those in favor?
Aye.
Any opposed? That motion passes.
Ms. Kirsten?
Yes.
This is Brett Cant. You have a copy of the stipulation. If you could please execute the signature page and scan it and send it back to the board, I would appreciate that.
Yes, I'll resend that to you.
Thank you.
Okay, thank you.
Great, thank you both for your time today.
Thank you.
All right, next we'll go to agenda item 5J, that's for Hill Rom. If we have representatives here for Hill Rom, if you please come forward.
Careful, Bill.
Well, it's briefcase, you got a strap. That's why they tell you when you go into, when you put your bag under your seat in the airplane, not to face the strap.
You're not a candidate for the exit row, you're correct.
Hi, good morning.
Good morning.
I'm gonna have you both state your full name and titles for the record.
William Stilling, Bill Stilling, representing Hillrock.
And Daniel Mallory, representing Baxter International, who owns Hillrom as regulatory counsel.
Okay, and then are you licensed in Nevada?
I am in-house counsel for Hillrom, so
Okay, so do I swear Mr. Mallory in?
He's actually, I think, similar to Mr. Convery, he's a company representative. He's not here acting as a lawyer. That's why they hired him. So
All right, then,
he's a witness.
Mr. Mallory, I'll swear you in. If you join me raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete? Thank you so much. All right, Mr. Camp.
Brett Camp, for the record, prosecuting this matter on behalf of the state. This is case number 24-500-MP-S, Respondent Hillrom Company Incorporated, license number MP 00038. The charging document appears beginning on page 2710 of the board book. The answer and notice of defense was filed by the respondent, appears beginning on page 2720. And we do have a stipulation for your consideration and possible approval that we're going to present this morning, which begins on page 2725. So by way of brief background, in this instance, the respondent was charged with engaging in the business of selling, leasing, supplying, and or distributing prescription medical devices to hospitals and other licensed healthcare facilities in the state. While holding a license as a medical products provider, but without a license to engage in business as a wholesaler. And so in order to resolve this matter short of a hearing, we are proposing that the respondent pay a fine of $2,500 for the violations and $500 to partially reimburse the board for recoverable attorney's fees and costs. I just also want to note two things. One, the operation was also hit with a $5,000 citation and fine for unlicensed activity, which was paid. And the respondent has also applied for a wholesaling license. I believe that that application will be on the agenda for the next board meeting.
If I can just add, thanks, I'm to David for the record. The fine goes to the general fund, so it doesn't come back to the board, but you know that, but I like to state that for the public. And then, I mean, they make excellent products. We all use them. We're glad that they have the products. It just was the issue of not being licensed.
Board members. Oh, I'm sorry, Mr. Stilling or Mr. Mallory, did you want to add any comments or?
I would also say that we're in agreement. We negotiated this as always. We can work with Brent and I think as I understand it, the main products that they had, they sell beds. And I think now they sell them to hospitals, nursing facilities and such. And they, the beds sometimes have sensors. Beds are not prescription devices, the sensors are. That's where the, incorrect places come to stuff. That's what it was about.
and I'll add, we are excited to get this behind us so we can return to providing these products that help, are another tool in the arsenal of nurses and doctors and hospitals. Patients.
Great. Any questions for Hillrom?
No questions. Adam Porth, for the record, I move that we approve the stipulation as outlined by board staff in case against Hillrom.
Crystal Freitas,
Second. We have a motion by Mr. Porath, a second by Ms. Freitas. Any further discussion? All those in favor?
Aye.
Any opposed? Okay, that motion passes. We thank you for your time.
Thank you all.
All right, we'll move to agenda item 5Q. That's for Pulmonary Solutions LLC. So we have representatives here for Pulmonary Solutions. If you could please come forward.
Good morning, Madam President. Lynn Biggs on behalf of Pulmonary Solutions. Oh, pardon me, let me lower my hand, trying to lower my hand. I also believe that I have Michael McClendon of Pulmonary Solutions on the line. I don't know if he's raised his hand.
We'll take a look.
Yes, I'm here. Michael McClendon with Pulmonary Solutions.
Great. Anyone else joining you both today?
I don't believe so.
No.
So, Mr. McClendon, I'm going to swear you in. If you could join me in raising your right hand. Do you
Sure.
swear that the testimony that you're about to provide will be both truthful and complete?
Yes, I do.
Okay, great. Thank you. And Mr. Zanino.
Thank you, President Park. This is a matter of Nevada State Board of Pharmacy versus Pulmonary Solutions, license number MP 02951, case number 22357 MPN. The notice of intended action and accusation begins at page 2911 of your board book. The parties have drafted a stipulation and proposed order for your consideration and possible approval. That is in your board book. It begins at page 2929 of your board book. Scroll to that briefly. Just outline the kind of the key provisions in that. So the allegations against Pulmonary Solution are summarized at paragraph 6, which is page 2929 or 2930. Response that provision states that respondent does not contest the allegations stated in counts 1 through 8 of the accusation on file herein, and admits that the evidence exists and that board staff prosecuting this case could present evidence at a hearing to establish a factual basis for the following. Between August 2020 and March 2024, respondent engaged in business as a medical products provider under license number MP 02951 issued by the board for a registered location at 50 Freeport Boulevard in Sparks, Nevada. So here I'll note that that respondent had 2 locations, one in Sparks and one in Las Vegas. The issues in this case involved the Sparks location. As far as we know, there have been no issues at the Las Vegas location. The allegations are that with respect to one elderly, vulnerable patient, the respondent failed to service respiratory equipment, failed to maintain it, failed to make proper documentation of communications. Essentially, at some point, I think that the respondent closed up that location, probably realizing that they couldn't staff it properly. They let that license expire, but the location in Las Vegas remains. This stipulation and the proposed penalties do not affect the Las Vegas location. The proposed penalties are as follows. The respondent acknowledges that the license in question MP 02951 was forfeited when they did not renew it. They agreed to pay an aggregate fine of $8,000. They've agreed to pay the sum of $1,000 to partially reimburse the board for recoverable attorney's fees and costs. We agree that the other license, as I said, remains in full force and effect without probationary terms, conditions, or restrictions. I'll note that as a condition of this, that the board has agreed to dismiss count number 9. I don't think there's evidence that we could use to prove that count up. So that's part of, so if this stipulation is approved, count 9 of the accusation will be dismissed. The remaining counts 1 through 8 remain. Respondent agrees and understands that the stipulation will be reported to the National Practitioner Data Bank. With that, I'll defer to the board with any additional questions.
Zunino. Ms. Beggs, did you want to add any additional remarks?
Not today, Madam President. We would simply ask that the board accept the settlement as presented today.
Great. I do have just a couple questions perhaps for Mr. McClendon, with the,
Yes.
what happened with the patient in the Sparks location? It just seems like a series of, unresponsive times, not repairing equipment. Can you comment a little bit about why that was? I think Mr. Zunino alluded to perhaps it was staffing related.
Yes, so this all kind of occurred during the COVID time period, and very hard to staff the location. During our tenure as a company, we've had very good success rates with communication and outreach and local, state, and federal inspections. And we feel like this was just a one case where it just fell through the cracks. And unfortunately, we were not able to adhere to the guidelines for this patient in this location.
Okay, and then I know that this is a separate location, and then you have your Las Vegas location. I just want to know that this is not something that we would see at your Las Vegas location, or if you've made any changes, or if you have policies and procedures that would prevent this in the future.
Yes, we have quality staffing in Las Vegas that have been with us for many years, decade at least. We've recently upgraded our communication system, our phone system, to a more comprehensive system that would allow us to track in and outbound communications at a more prominent level during this.
Okay, all right, thank you. All right, board members, any additional questions for Pulmonary Solutions?
Just from the end, it's an interesting case because like if the business was still in effect, it would be one thing and that's something else. So I know that you will weigh that when you do your decision. But stipulations are done by us to try to come to a conclusion, but you may have additional questions, obviously.
Thank you. Board members, any additional questions?
I don't have any additional questions. I would move that we accept the proposed stipulation for Pulmonary Solutions. Oh, with the suggested amendment, we're striking accusation paragraph 9, correct? Is that written?
Count 9 would be dismissed, yeah, and that's stated in the stipulation.
Adam Porth for the record. I struggle with this one a little bit. The allegations in this case are pretty serious, and I think I would just echo the sentiments that if this was a business that was still ongoing, I would have major concerns. And so I'm glad to hear that we don't have any concerns about the Las Vegas location. The fact is, this was an 88-year-old person that had COPD, that had oxygen needs that were not met. And so I just really want to have some assurance that business in Las Vegas is much different than what was laid out in this case.
Dave, inspections are a path. You can modify a step and have to go agree to it, but you have tools at your disposal to. It's for your decision. So, board staff does the work and you make the decision.
I guess I would ask clarification from board staff on inspections of, I don't know if Joe.
I'll answer it.
whoever's doing those inspections, do we have evidence that regular communication is being documented with patients that as it was not happening in this case? Have there been any service complaints at the Las Vegas location that need further investigation?
As far as complaints, service complaints to them, which they may get, we would not necessarily see. We have no outstanding complaints to us, and that was weighed as we were going through this process because of the timing and where the locations were. Board staff, when they do an investigation for that or inspection, are thorough, and they'll look at patient charts and that kind of stuff. But if that's, and I mean, it's not that I don't share your concern, I share your concern. So if we need to dig into that, we would probably have to do a special inspections, which we can do without you putting in the order. Like, we can go inspect whenever we want, and we would probably do that. But if you want to put it into stipulation, that's a tool that you have at your ability. So those are, no, if you had other complaints, we would bring it to your attention at this time, to us.
Adam Porth for the record. I guess I would feel more comfortable if we had one additional inspection of the Las Vegas facility to make sure that there's not similar issues.
With a focus on this, we can see how did they receive, questions and complaints back to them, and what do they keep a record of them? Well, we can look at that. We can dig into it from that perspective.
Yeah, I would, I think one additional inspection is, it's quite minimal based on, what has occurred. I think in knowing that the Sparks location has closed, I think that does weigh into, me feeling more comfortable with the decision, but, I share a lot of good concerns. That's why I addressed that question to Mr. McClendon about what are you doing differently? Does this happen in Las Vegas? But I think an additional inspection would make me feel more comfortable, certainly be in favor of that.
Would you like just one?
May I interject here, please?
So this is Lynn Beggs. So I just want to be very clear here. The settlement itself is on the Sparks location license, not the Las Vegas location license. So if the board is saying they want the stipulation to be modified, I certainly can talk with Mr. McClendon about that. I do want to bring up 2 points. One, this happened over 4 years ago during the pandemic. There have been no complaints. There's been no issues. There's been no issues with the inspections of Pulmonary Solutions since that time. This was an outlier issue. Further, I just want to address the issue of the patient's oxygen needs were not being met. That is inaccurate. The patient did have another unit. The patient's unit was being serviced. There were some delays, and it eventually was changed out. So I want to make sure that the board understands that this was not an 88-year-old man who was going out without oxygen for multiple months.
Dave, for the record, I'd like to jump over to board members. We don't, hold on, sir. We can just do the inspection.
Yeah.
So I think I think what Lynn's saying is not that you couldn't do it, but they'll have to agree to it. I think that that's well within your purviews. Or there's other actions that we could take that might be more onerous to do that. I think that if that's what you're saying you want, we can go do that outside of the stipulation, and we will. So.
Yeah, I'm not particularly concerned because I know that that is within our ability to do. So if we want to keep those separate, we could certainly keep it separate.
Yeah, having had that discussion, I would second to accept the stipulations written.
Okay, so we have a motion by Mr. Cobo, second by Mr. Porath. Any further discussion? Okay, hearing none, all those in favor? Aye. Any opposed? Okay, that motion passes. All right, thank you for your time.
Thank you.
Thank you.
For the minute taker, we'll put that in the minutes, so we'll go do it. That'll be our placekeeper, because we won't have it in the order, so we'll put it in the minutes.
I got it. We will go to agenda item 5S. That's for Michael Vargas Lagunas. So we have Dr. Vargas Lagunas, representatives here. Please come forward or raise your hand.
I'm here.
Okay, great.
Can you see me?
Yes, we can see you, and it looks like there's one other person, Mr. Tyndall. Is he unmuted?
I am now. Thank you. Good morning.
Okay, great. All right, is it just the two of you today?
Yes.
Yes.
All right, if I can have you both state your full name and titles for the record.
I am Dr. Miguel Ángel Vargas Lagunas. I am an internal medicine doctor practicing in Nevada since 2007, 2008.
Thank you.
And I'm Randy Tyndall, Dr. Vargas Lagunas' attorney.
So, Doc, I'm going to swear you in. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes, I do.
Thank you. All right, Mr. Zunino.
Thank you, President Park. This is the matter of Nevada State Board of Pharmacy versus Miguel Vargas Lagunas, MD, case number 22490 CSS. The notice of intended action accusation begins at page 2958 of your board book. The parties have drafted a stipulation and proposed order for your consideration. That stipulation does not appear in your board book. It was kind of finalized after we published the board book. But I believe you have digital copies and or paper copies in front of you. So I will cover the key provisions. The allegations are summarized at page 7, or rather paragraph 7 of the stipulation. Respondent does not contest the allegations and acknowledges that board staff could present evidence at administrative hearing to establish a factual basis for the violations. To wit, in 2022 and 2023, respondent, a licensed physician, served as the medical director for Imagine Medical Spa. During his tenure, a non-practitioner owner was in possession of and or administered dangerous drugs when respondent was not present. As the medical director, duty to ensure that drugs were secured and that they were not administered by unlicensed persons or persons acting outside of the presence of a practitioner. Paragraph 9 outlines the proposed penalties. Respondent shall accept the stipulation orders of public reprimand. Respondent shall pay a fine of $5,000. Respondent shall reimburse the board for recoverable costs and fees in the amount of $1,000. And respondent understands that this matter will be reported to the National Practitioner Data Bank in accordance with federal law. With that, I'll defer to the board if they have any questions.
Before we go to any questions for the board, I'll turn it over to Mr. Vargas. Additional comments or remarks? Mr. Tyndall, did you want to make any additional remarks?
I apologize. I did not hear what you said just before you called my name.
Oh, Mr. Zunino provided a summary, and I just wanted to see if you had any additional remarks or anything you wanted to add on behalf of your client.
No, ma'am.
Dr. Vargas Lagunas, did you want to add any additional remarks?
No, I'm sorry that happened and it won't happen again. I'm trying just to serve my community, and I will do in the best care.
And then I was just curious in this case. So can you tell us a little bit about the circumstances? You signed up as medical director, but you were not present?
No, they were in my practice, located in 2465 Reynolds, and then they find another place to install the practice. It was maybe 7 miles away from my practice. In the case, my practice in Las Vegas, it was in Decatur, and they moved there, and they were in the process to move to the stores to reorganize that place. But in that reorganize, this was no good. So they didn't unlock the medications, they didn't put everything in place, and it happened.
Is the med spa still operating today?
It's operating, but just like the under the cosmetology rules. No, no more. They don't do more injectables, nothing like that. And we discussed this case with the Board of Medicine of Nevada Medical Board, and they decided that they need to do just cosmetology, nothing medical. And I am already out of that medical director. Just Liliana is doing the procedure like the cosmetic laser treatment, but she has already the license to do the cosmetic and the training laser treatments.
So you do not currently serve as the medical director there?
No more.
So no association?
It's no position already.
Dr. Adam Porth, for the record, do you serve as a medical director of any other medical spas currently?
No.
Thank you.
Okay, any additional questions? Board members?
I don't have any other questions. It's Crystal Freitas for the record. I'd move we approve stipulation in order for Dr. Miguel Vargas Lagunas.
Yes.
Okay, we have a motion by Ms. Freitas, a second by Mr. Porath. Any further discussion? Hearing none, all those in favor?
Aye.
Aye. Any opposed? Okay, that motion passes. We thank you for your time today.
President, I would suggest maybe a quick break. And then we'll go to our other.
All right, we'll take a quick break. We're gonna go ahead and move forward with our agenda items. We'll go to agenda item 5N and 5O. That is for Matthew Okiki. So if we have Dr. Okiki or representatives, please come forward.
Madam President, Dave Weeds for the record. Again, for the record, I'll just note Jay Jacoba is out, but we expect her right back. Will Parker present.
Hi, good morning.
Morning, Madam President.
If I could have you state your name for the record.
Gregorio Zamora, counsel for Dr. Kiki.
Will Dr. Okiki be joining you today?
No, ma'am.
So with that, I'll turn it over to Mr. Okiki.
Thank you, Madam President. This is the matter of Nevada State Board of Pharmacy versus Matthew Okeke, MD. The parties have drafted a stipulation and proposed order for your consideration and possible approval. The stipulation does not appear in your board book. The parties finalized it on Monday, but I do believe you have paper copies or electronic copies that were emailed to you. The stipulation and proposed order would, it consolidates and settles the allegations in two cases, case numbers 19013 CSS and case number 25241 CSS. The first amended notice of intended action and accusation in the 2019 case begins at page 2824 of your board book. And I'll note, because I'll cover the procedural history briefly, just so that we kind of put this stipulation in context. There was a default order that you entered in, and that appears at 2814 of the board book. I think there was a misunderstanding as to whether Mr. Aguirre had forwarded a stipulation to us or not, and so ultimately that order was vacated. That appears at page 2813. I think that was in January of 2024. After that, the Board of Medical Examiners filed several accusations against Dr. Okeke, and in their accusations, they included many of the same accusations that we had set forth in the 2019 case. And so Mr. Aguirre and I agreed to postpone that pending the disposition of the cases before the Board of Medical Examiners. In that case, there was a 3-day evidentiary hearing before a hearing officer. The hearing officer made recommendations, findings and recommendations. Those appear at page 2790 of your board book. The Board of Medical Examiners ultimately approved those recommendations in an order dated June 13th, 2025. That appears at page 2779 of your board book. Based upon that order, the staff filed an additional accusation against Dr. Okeke because there was one allegation that was covered in the Board of Medical Examiners case that was not covered in the 2019 complaint. So that complaint appears, or that accusation appears at page 2889 of your board book. And the accusation essentially is that Dr. Okeke engaged in an intimate relationship with a patient, and during that time frame, prescribed controlled substances. The Board of Medical Examiners found that that was a violation of the Medical Practice Act. Because it was drug related, we've included that in an additional accusation. But as I said, this stipulation will cover all that. So the stipulation is, I think, noteworthy for one reason, and that is that Dr. Okeke waives his right to litigate this stipulation. There's no, he's going to litigate this with the Board of Medical Examiners, I suspect. This stipulation kind of ensures that the Board of Pharmacy does not become kind of a party to lengthy, kind of complicated litigation in the district court. And ultimately, the terms are: respondent in paragraph 8 does not contest the allegations stated in the two accusations and admits that evidence exists to establish a factual basis to resolve those allegations. The parties have agreed that the respondent's certificate of registration is revoked effective immediately. The respondent shall be ineligible to petition for reinstatement for a period of 1 year. And I want to note, just a note on this: this is not a commitment to reinstate his medical or his CS registration. It's just a term of eligibility after which he could apply for reinstatement. Ultimately, the medical board and the proceedings with the medical board will determine if and when he can apply for a new medical license, and then he would have to appear independently, and you would, make a separate determination as to whether he qualifies for a CS registration. The respondent agrees to pay a fine of $10,000 if and when he submits a petition for reinstatement, and he agrees to pay for costs and fees the amount of $3,000 if and when he submits a petition for reinstatement. This matter will be reported to the National Practitioner Data Bank. And as I said, it results in a revocation. It's a fairly simple resolution of the charges in this case. And ultimately, the respondent waives his right to litigate against the Board of Pharmacy.
Greg, can I just add one? Greg said, but I just want to solidify it a little bit more. Currently it's 7 years with the medical board. He has to have that license to get here. So if that 7 years stays in effect, it'll be 7 years for. We purposely did 1 year to give him breathing room with the medical board. If he gets that reduced, then he doesn't have to come back to you. So if say it's reduced to 3 years, it'll be 3 years with. So the 1 year is the minimum. It'll be a minimum of 1 year for you guys. But we purposely did match that up so that we didn't have to go take the step if he's able to change that with the medical board in the next 7 years.
All right, so with that, I'll turn it over to Mr. Aguara for any additional comments or remarks on that.
No, just present. Okay.
Right. Board members, any questions or comments on the stipulation as proposed?
Adam Port for the record, just to clarify, Dr. Okeke does not have a medical license currently in the state. Okay,
Just,
all right.
and furthermore, that would have to be resolved before he could ever petition.
That is correct.
Yeah, I think initially I was thinking, why aren't we mirroring the terms? But regardless, it's whatever the medical board, if it's 7 years, he can't come in front of us for another 7 years. So I wasn't too concerned about that. Okay, any questions or comments?
No further questions. I would move that we approve the stipulation for Dr. Okeke to resolve cases number 19-013-CS-S and case 25-241-CS-S.
Crystal Freitas, I second.
Okay, we have a motion by Mr. Horace, a second by Ms. Freitas. Any further discussion? All those in favor?
Aye.
Any opposed? That motion passes. Thank you.
Thank you.
All right, with that, we'll move to item 5E, and that's for Wells Pharmacy. We have representatives here for Wells Pharmacy. Board. Hey, hi, good morning.
Morning.
If I can have each of you state your full name and titles for the record.
My name is Jeremy Kilbert. I'm ProHoc Chase sponsor for Council Mason Law.
Melissa Stepko, Senior Vice President of Regulatory with Wells Pharmacy Network. Melissa, I'm sorry, could you repeat your last name? Stepko, S-T-F-K-O. Thank you.
I'm Jason Bavo, counsel for Wells Farms.
Todd, for just the board members, can you explain what that means, from the legal basis there?
Senior Deputy Attorney General Todd Weiss, ProHoc VJ just means that counsel is licensed in the state and he is giving a special permission for the sponsor to appear for this matter, even though the matter of Nevada 12 license.
As far as swearing in, does he need to be sworn in then?
No, he's a counsel of record. It all means is that he's received special permission to appear for a single matter in Nevada without license.
Then in this case, just Melissa Stepko. Right. Do you swear that the testimony that you're about to provide will be both truthful and complete? Thank you so much. All right, Mr. Cant.
Greg Camp for the record, prosecuting this matter on behalf of the state. This is case number 23-050-PH-O, Wells Pharmacy Network LLC, pharmacy license number PH 01589. The charges begin on page 2612 of the board book, and then on page 2617. Or excuse me, yes, 2617, incorporated into the charging document is a settlement agreement with the Missouri Board of Pharmacy that partially forms the basis for this action. And then respondent's answer and notice of defense appears beginning on page 2637 of the board book. We do have an evidentiary hearing to conduct here today. I would suggest that we maybe take a brief break to set up for witnesses, because we both are going to be calling witnesses, so we probably need to figure out how we want to set that up.
Great, we're happy to take a break if you request it. I think because you guys have filled up the table, which is no problem. We have the open microphone next to Darlene, and we were just gonna put all witnesses there. And that way the public can hear them, and I have the camera set up so that the public can see that witness. So if that's okay with everybody, that's where typically they go to this table, but you've filled that. Is that okay? Council's?
With that, by way of a brief opening statement, there are essentially two factual allegations as set forth in the accusation that formed the basis of this action. First, and I actually, in the course of presenting the factual allegations, I do want to amend the charging document on the record. Paragraph 2 of the accusation indicates that from January 1st, 2002 to February 9th, 2023, respondent compounded and dispensed at least 20 prescriptions to Nevada patients for progesterone 100 milligram and 200 milligram capsules in olive oil without a statement of significant difference for each prescription, documenting a medical need specific to the patient for the compounded drug product. Those dates, I want to amend the date. It's not January 1st, 2002. It's January 1st, 2022. So I just want to amend that on the record. So that's the first allegation. And then the second allegation once again arises from the settlement agreement with the Missouri Board of Pharmacy that the respondent entered into on or about January 20th, 2023, imposing discipline on the respondent's pharmacy permit in Missouri for numerous violations of federal and Missouri state law related to compounding drug products and dispensing controlled substances. So that's this are the charges that I'll be presenting evidence and witness testimony in support of today.
Mr. Ballo.
Yeah, just like to note that this was some time ago, to 2023, my client dispenses thousands of prescriptions every day. This was a clerical error to not include the statement of significant difference. Each prescription was well documented with noting that each progesterone would be with olive oil due to patient needs. Usually it was due to an allergy to peanut oil, which is in the commercially available product. So each patient knew what they were getting based on the prescription. There's no safety issue with this. And again, 28 prescriptions out of thousands. And we have since changed our practices and made sure that these statements go out with every prescription that is sent in every state that we operate in. And we're just looking for a little leniency here on this. We have been on probation, Missouri, for the exact same situation, progesterone with olive oil, lack of statement, and the reciprocal whirlpool that we get sucked into with these just never ends. So, once we have it once, we feel like we repeated violations for the same actions again. Are excessive. And I would note that management and the supervisors at Wells have changed since this time, and it's a lot more well run with attention to detail now. The appropriate precautions in place to ensure this doesn't happen in the future.
Okay, thank you. I'll turn it back to Mr. Camp.
Greg Camp for the record. So with that, I'd like to call Ken Schubert to the stand to testify.
Hi, good morning.
Morning.
Glad you state your full name and
Kenneth Schubert, I'm an investigator for the Board of Pharmacy.
Mr. Schubert, I'm going to swear you in. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Greg Camp for the record. So Mr. Schubert, what's your position with the Board of Pharmacy?
I'm an investigator for the Board of Pharmacy.
Okay. And how long have you been an investigator for the Board of Pharmacy?
I've been an investigator for 14 plus years.
And what's your experience prior to coming to the Board of Pharmacy?
I spent 38 years in drugstore retail.
Okay. Are you a registered pharmacist?
I am not.
And you conducted an investigation in case number 23050 PHO regarding Wells Pharmacy Network?
I did.
And what caused you to initiate that investigation?
Wells Pharmacy self-reported based upon the action that Missouri Board of Pharmacy took.
Okay. And in the course of your investigation, I've provided what I've labeled Exhibit A, proposed Exhibit A. I provided copies to counsel for the respondent and the president and the board counsel. Could you please look at Exhibit A and tell me if this reflects your initiation of the investigation and contacting the respondent?
Yes, it does.
Okay, and just for the record, this document space stamped pages 010 through 015 appears to consist of 3 pages of an email exchange preceded by 3 pages of what appears to be a dispensing report. Is that correct?
That's correct.
And could you just detail for us the substance of this email exchange?
Well, this is when I opened up the investigation, I was trying to determine what products in general that were being shipped into Nevada from Wells Pharmacy. And our focus was on the progesterone, which in this document, it provides essential copies of 100 milligram and 200 milligram capsules.
This is a true and correct copy of your email exchange with, and who is Sarah Thron?
Sarah Thron was the person that was in their corporate office I was dealing with.
And this true and correct copy of your email exchange with her?
That's correct.
And the dispensing report you received redacted in accordance with law?
That's correct.
Okay. I would move that this be admitted into evidence as Exhibit A.
Mr. Ballard, have you had a chance to review the documents?
I have,
Any objections?
I have no objection.
Okay, so admitted as Exhibit A.
And while copies are provided to board members, Mr. Schuber, you noted that in the dispensing report reflected that a change had been made from the commercially available FDA-approved product and olive oil had been included.
That's correct.
Okay, and I recognize you're not a pharmacist, but why is that relevant in your mind?
Well, again, these are the 100 milligram and the 200 milligram are essential copies.
So is every prescription that's listed on this dispensing report constitute an essential copy?
No, the 125s and the 50s do not.
Okay. And as a result of your receipt and review of the dispensing report, did you have a further email exchange with Ms. Thron?
I did.
Okay. And I'm going to have provided you a copy of what is proposed Exhibit B. Copies provided to council and board president. Note that the date stamp numbers in proposed Exhibit B are 047 through 051. Mr. Schuber, as you take a look at that document, this appears to be a further email exchange that you had with Ms. Thron.
That's correct.
Okay, and in this email exchange, she also, as an attachment, provided copies of the prescriptions to you.
Well, in this one, on 050, she had responded when I asked for the reason why progesterone was compounded with olive oil. She provided some clinical information on 0.050.
Okay, so before we get further, this appears to be a true and correct copy of your subsequent email exchange with Ms. Thron.
Yes, it is.
I would move that this be admitted into evidence as Exhibit B. Copies provided to the board.
Mr. Ballo, have you had a chance to review?
I don't have any objection.
Okay, so admitted as exhibit B.
Okay, and once again, you just testified that in response to your query requesting copies of the prescriptions, Ms. Thron provided you copies of the prescriptions and some clinical information.
That's correct.
Okay. And I'm going to show you next what is proposed exhibit C. Have copies provided to council, board president. Note for the record that these documents are date stamped 016 040. And Mr. Schubert, does this appear to be copies of the prescriptions that you received from Ms. Thron in response to your request?
Yes, it is.
Redacted, of course, in accordance with law.
That's correct.
Okay, and they appear to be true and correct copies of what you received from Ms. Thron.
That's correct.
Okay. In that case, I would now move to have exhibit C admitted into the record.
Any objections, Mr. Ballo?
No objection.
Okay, so admitted as exhibit C.
And while copies are passed out to the board members, when you reviewed these prescriptions, did you make a determination as to the change in the FDA-approved product and the substitution? Well, I guess I should ask. Olive oil was substituted for what in the FDA commercial available product?
For peanut oil.
For peanut oil. Okay. And when you reviewed the prescriptions, did you have any questions about the fact that the change had been made from peanut oil to olive oil?
The one thing I didn't see on the essential copies was there was nothing identified as a statement of significant difference.
And what, to your understanding, is a statement of significant difference on a prescription?
It would have to do with a reason why that prescription was being compounded with something other than what's commercially available.
In the absence of a statement of significant difference documenting a medical need specific to the patient on each prescription, did you pose the question to Ms. Thron as to why there wasn't a statement of significant difference on each prescription?
I did.
And what was the response you got?
Well, the response that was that they did not include that on these prescriptions.
Okay. And you had a subsequent email exchange with Ms. Thron?
Yes.
Okay, and so I'll show you what is proposed exhibit D. Ask that copies be provided to opposing counsel or president. Please take a look at proposed exhibit D. Note for the record, it's date stamped 067 071. Is this a copy of your subsequent email exchange with Ms. Thron after your receipt and review of the prescriptions?
Yes, it is.
Okay, it appears to be a true and correct copy of your email exchange.
Yes.
I would ask that this be admitted into the record as exhibit D and copies provided to the board.
Any objections, Mr. Ballo?
No objection.
Okay, so admitted as exhibit D.
All right, and so, Mr. Schubert, looking at the exhibit D on page 067, it appears you posed a question to Ms. Thron regarding the inclusion or omission of a statement of significant difference. And it looks like you attached FDA information.
I did.
Ms. Thron's reference. Okay. And we'll be coming back to exhibit D, but I'm now going to provide you a copy of proposed exhibit E. copies are provided to council and the board president. I'll note for the record that Exhibit E, proposed Exhibit E is date stamped 052 through 066. And ask, is this a copy of the FDA information, as you called it, that you referenced in your March 31st, 2023 email to Ms. Thrawn?
Yes, it is.
Okay. And just note for the record that this document's titled Compounded Drug Products that are essentially copies of a commercially available drug product under Section 503A of the Federal Food, Drug, and Cosmetic Act, correct?
That's correct.
And where did you obtain this document?
Actually, I got it from one of our inspectors, Mr. Joe Dodge.
So Mr. Dodge provided this document to you?
Yes.
Okay. Did you request the document from Mr. Dodge?
It was in our discussions, we thought it was best to provide him with that information, since that was our area of
What's
concern.
Mr. Dodge's role in this investigation?
He is my supervisor.
Okay,
And
so in the course of the investigation, you consulted him and
I
received
did.
direction?
I did.
And he provided you this document,
That's correct.
and then you provided this document to Ms. Thrawn.
That's correct.
And moving back to your email correspondence with Ms. Thrawn that's been entered into the record as Exhibit D. Did she have a response to you? It looks like there may have been a response on page 070.
She did.
Okay. And before we move on to those questions, I think I haven't had Exhibit E admitted into the record yet. So if there's no objection from council, I would like this document to be admitted into the record as Exhibit E.
No objection.
Okay, so admitted as Exhibit E.
So going back to your email exchange with Ms. Thrawn, that's Exhibit D. On page 070 in her email response, could you just read that response into the record?
It says, Mr. Schubert, we are confirming receipt of your March 31st, 2023 email and request for statement of significant difference for the RXs listed on your original request. The individual prescriptions requested provided on 3/13/2023 do not include a statement of significant difference as advised per FDA guidance. Compounded drugs, drug products that are essential copies of a commercially available drug under Section 503 of the Federal Food, Drug, and Cosmetic Act. Wells Pharmacy Network LLC has provided an explanation on the difference of our compounded products to the essential copies commercially available and is committed to maintaining compliance with all federal guidance and Board of Pharmacy regulations. To eliminate any potential ambiguity, Wells Pharmacy Network has ceased compounding progesterone 100 milligram and 200 milligram capsules in olive oil as of April 14, 2023.
So in her response, Ms. Thrawn's admitting that the prescriptions that were dispensed to Nevada patients did not contain a statement of significant difference.
That's correct.
Okay. With that, I have no further questions for Mr. Schubert.
Mr. Ballo, any questions for Mr. Schubert?
Yeah. Mr. Schubert, correct?
Yes.
Okay, thank you. The FDA guidance document, is it your understanding that that lists requirements for compounding pharmacies? Or is it just recommendations?
Well, I think it's a recommendation, but that's certainly outside my purview.
And looking at it, you've attached an Exhibit E. At the top of each page, it says contains non-binding recommendations. Is that correct?
That's correct.
The in your role as an investigator, do you have an understanding of why there is a recommendation by the FDA to include a statement of significant difference with prescriptions?
In my role, I'm responsible for gathering data regarding an investigation.
And in your role in gathering data, where would you expect to find a statement of significant difference?
On the prescription.
On the prescription provided by the doctor?
That's correct.
Okay, thank you.
I have nothing further for the witness.
Okay, board members, any questions for Mr. Schubert? Okay, thank you, Mr. Schubert.
Next, I'd like to call Board Inspector Joe Dodge to testify.
Good morning,
State your full name for the record.
Joe Dodge.
Mr. Dodge, I'm gonna swear you in. Do you swear that the testimony that you're about to provide will be both truthful and complete?
I do.
Mr. Dodge, your position with the Board of Pharmacy is Board Inspector?
That's correct.
Okay, and Mr. Schubert testified that you are his supervisor?
I was at the time.
Okay. And how long have you been with the board?
9 years.
Okay. Are you a registered pharmacist?
I am.
What, if any, experience do you have related to compounding drug products?
Prior to my time with the board, I worked at a home infusion company for 25 years and we did sterile compound.
Sterile compounding?
Correct.
Okay. Was sterile compounding in any way relevant to the prescriptions at issue in this case?
This is non-sterile compound.
This is non-sterile compounding. What, if any, experience do you have with regard to non-sterile compounding?
During my 9 years with the board, I've inspected numerous locations that perform non-sterile compounding.
Do you have any formal training or certifications related to non-sterile compounding?
No certifications, but I've definitely gone through training through national organizations for non-sterile compounding.
Okay. And you should have copies of all the exhibits that have been admitted into evidence. So I'll start by asking you to refer back to Exhibit A. And the dispensing report that Mr. Schubert received from Ms. Thrawn, and ask you to review the dispensing report and tell me what it means to you.
It appears that they were compounding product that was progesterone in olive oil, which is different than the manufactured product, utilizing the same strength that's available in manufactured products as well with the 100 milligram and 200 milligram capsules.
And to your knowledge, why would a pharmacist compound this drug product with olive oil instead of, well, first of all, what would typically be there in place of olive oil?
The manufactured product contains peanut oil.
Okay. And to your knowledge, why would a pharmacist compound this drug product and change peanut oil to olive oil?
I would assume potentially due to allergies to peanuts.
An allergy, okay. And is peanut oil in the compounded drug, or in the commercially available drug product, excuse me, is it an active or inactive ingredient?
Inactive ingredient.
Okay, and what's the difference between an active versus inactive ingredient in a drug product?
The active ingredient is the main therapeutic drug that would be utilized for the treatment of whatever the disease state is.
And then what's the purpose of the inactive ingredient?
It would just be something to help administer the product to the patient. So it's a vehicle.
Okay. And so you testified that in this instance, to your knowledge, the substitution of peanut oil with olive oil would be to address an allergy concern for the patient?
That would be my assumption.
Okay. And asking you to move on now to Exhibit B. In which Mr. Schubert had an exchange with Ms. Thrawn subsequent to the review of the dispensing report, requested copies of the prescriptions and received an email from Mr. Schubert received an email response from Ms. Thrawn. Which I believe is dated February 17th, 2023. This is the page bait stamp 048. And it appears she included clinical information on the benefits of utilizing an olive oil formulation. Did you have a chance to review her email response?
I did.
What did it mean to you?
I don't think there was a question about whether or not the medication that they compounded in olive oil was a benefit to patients. It was just whether or not it was meeting the requirements of the FDA guidance.
Okay. So moving on to what's been admitted into evidence is Exhibit C, the copies of the prescriptions that Mr. Schubert received from Ms. Thrawn in response to his request. And once again, they have been redacted to conform with Nevada law as to some personal identifying information, but I think believe all the information relevant to this hearing today and the charges is available to you on the prescriptions. So can you tell me, reviewing these prescriptions, what, if any, conclusion you drew about the changing in the compounded product to utilize olive oil instead of peanut oil?
Yes, Investigator Schubert and myself were looking to see if there was the statement of significant difference available on the prescription for each individual patient, and we did not find that information on it.
Okay. And what's the relevance of the omission of a statement of significant difference?
Based upon the FDA guidance, the information should be listed on the prescription. If not, the pharmacist has the availability to contact a practitioner, receive the information verbally, and then put the information directly on the prescription as well.
And what, to your understanding, is the whole purpose of a statement of significant difference when a compounded drug product has a change to it that, you know, as compared to the commercially available product?
I believe the purpose through the FDA guidance is for the practitioner to identify for each individual patient why that product is needed as opposed to a manufactured product.
Okay, and what does it mean to be an essential copy of a commercially available product?
I believe I should probably go through Exhibit E if you'd like me to.
Okay,
discuss.
let's jump to Exhibit E. You've got a copy of it there, and take us through this document and what it's relevant to this investigation, this hearing.
Perfect. So this is the FDA guidance as it's related to essential copies. It's dated January 2018. So I just wanted to review some of the information on here for the board members. And we'll assume once again that Wells Pharmacy had provided progesterone capsules in 100 milligram and 200 milligram strengths. So the 100 and 200 milligram strength is available commercially. So they were using the same active pharmaceutical ingredient as a commercially available product. And it was the same route of administration. It was the oral administration. So just a few things I'd like to review on the guidance. First is on page 1. So I'd like to read the first paragraph under introduction and scope. To qualify for exemptions under Section 503A of the Federal Food, Drug, and Cosmetic Act, FD&C Act, a drug product must be compounded by a licensed pharmacist or physician who does not compound regularly or in inordinate amounts any drug products that are essentially copies of a commercially available drug product, among other conditions. This guidance sets forth FDA's policies regarding this provision of Section 503A, including the terms commercially available, essentially a copy of a commercially available drug product, and regularly or in inordinate amounts.
So let me stop you right there and just ask you this question. would it be fair to say that a pharmacist that fails to follow this FDA guidance would not meet the exemption under section 503A of the FD&C Act?
That's correct, and that's actually on page 2 of this document. I can read
Okay,
what the
sorry.
exemptions are. No
Sorry, I
problem.
jumped in.
No problem.
Go ahead.
So on page 2 of the document, under background, letter A, section 503A of the FD&C Act. It states section 503A added to the FD&C Act by the Food and Drug Administration Modernization Act of 1997 and amended by the Drug Quality and Security Act in 2013 describes the conditions that must be satisfied for human drug products compounded by a licensed pharmacist and a state licensed pharmacy or a federal facility, or by a licensed physician to qualify for exemptions from the following 3 sections of the FD&C Act. The first one is section 501A2B concerning current good manufacturing practice requirements. The second is section 502F1 concerning the labeling of drugs with adequate directions for use. And finally, section 505 concerning the approval of drugs under new drug applications or abbreviated new drug applications. So to answer your question, my interpretation of this is if you would like to qualify for those 3 exemptions, you have to follow the essential copy guidance. Meaning you would not have to file a new drug application. You would be able to compound under USP 797 guidelines as opposed to good manufacturing products. And there's regulations regarding the labeling of drugs as well.
Let me ask one additional question. If you don't qualify for the exemption, you mentioned that means that any new drug product has to go through a formal application and approval process with the FDA.
Correct.
And also, do you typically see pharmacists or pharmacies engaging in that new drug application process, or do you see manufacturers?
Manufacturers.
Is there a different regulatory scheme for manufacturers than pharmacists that compound?
There is.
Okay.
I also like to read in the 4th paragraph, sorry, the 3rd paragraph under the background. The statute further states that the term essentially a copy of a commercially available drug product does not include a drug product in which there is a change made for an identified individual patient, which produces for that patient a significant difference as determined by the prescribing practitioner between the compounded drug and the comparable commercially available drug. The other things I would like to bring to the board's attention. This is on page 5. Under letter B, essentially a copy of a commercially available drug product. It states what is essentially a copy. And it states FDA intends to consider a compounded drug product to be essentially a copy of a commercially available drug product if the compounded drug product has the same active pharmaceutical ingredient, API, as the commercially available drug product. Number 2, the API have the same, similar, or an easily substitutable drug strength. And the commercially available drug product can be used by the same route of administration as prescribed for the compounded drug. On page 6, the last paragraph I would like to read as well. It states that we recognize that for some patients, a drug product that has the same API, strength, and route of administration may include a change that produces a significant difference for a particular patient. For example, a drug product compounded without a particular inactive ingredient may produce a significant difference for a patient who has an allergy to the inactive ingredient in the commercially available drug product. However, for other patients, this change may produce no difference at all. Congress did not intend for compounders to use, for example, the fact that some patients may have allergies as a basis to compound a drug without the inactive ingredient for other patients who do not have the allergy under the exemptions in section 503A.
Let me stop right there and ask you a question. How do you determine, looking at the prescription, whether the patient has an allergy or not?
You would need information from the practitioner that information is listed on the prescription.
Would that be the purpose of the statement of significant difference, and including that on the prescription?
That would certainly be very helpful.
Is there any other way, in the absence of a statement of significant difference on the prescription, to determine or to document the medical needs specific to the patient for the change.
Once again, it's contemplated in the guidance that the pharmacist could contact the practitioner and get that information verbally and then reduce it in writing on the prescription.
But once again, in either case, it would be reflected on the prescription
That's what the guidance is recommending, yes.
to document a medical need specific to the patient for the change.
Correct.
And once again, if that's lacking, then would the pharmacist or pharmacy essentially be it's not essentially, would the pharmacist be creating an essential copy and not qualify for the exemption?
That's how I interpret the guideline.
Okay. And if a pharmacist, to your knowledge, is producing an essential copy and doesn't qualify for the exemption, is that a violation of federal law?
Correct, if they're not following what the exemptions are. So if they didn't complete a new drug application, if they're compounding following USP 797 guidelines as opposed to CGMP guidelines, and then some labeling information as well.
And I realize you're not an attorney, but you're referencing in this guidance, section 503A of the FD&C Act, correct?
Correct.
And I believe that's codified in 21 USC 353A.
I don't know exactly what that is, but I would assume that you probably.
That's fine. But once again, a pharmacy, is it your opinion that a pharmacy should follow this FDA guidance document in order to ensure compliance with the federal law that it's based upon?
Correct.
Okay.
Just two more things I'd like to bring to the board's attention. On page 8, number 2, the first paragraph, this is related to statement of significant difference. It states pursuant to section 503A(b)(2) of the FD&C Act, a compounded drug product is not essentially a copy of a commercially available drug product if a change is made for an identified individual patient and the prescribing practitioner has determined that the change will produce a significant difference for that patient. If a compounder intends to rely on such a determination to establish that a compounded drug is not essentially a copy of a commercially available drug product, the compounder should ensure that the determination is documented on the prescription. At the bottom of page 8, the last paragraph, it states, however, if a prescription identifies only a patient name and drug product formulation, this would not be sufficient to establish that the prescriber made the determination described by section 503A(b)(2). And finally, on page 9, the first paragraph on page 9 states, if a prescription does not make clear that the prescriber made the determination required by section 503A(b)(2, or a compounded drug is substituted for the commercially available drug product, the compounder can contact the prescriber, and if the prescriber confirms it, make a notation on the prescription that the compounded drug product contains a change that makes a significant difference for the patient. The notation should be as specific as those described above, and the date of the conversation with the prescriber should be included on the prescription. And that's all the information that I thought was pertinent to this case from the guidance.
Okay. And from your review of the responses to Mr. Schuber's queries that Wells Pharmacy's representative, Ms. Thrawn, provided, can you in any way determine, looking at these prescriptions, what the medical need of the specific to each patient was for the change?
I could not.
Okay. And once again, in the absence of any documentation of medical needs specific to each patient for the change on each prescription, it's an essential copy that would not qualify for the exemption under federal law.
That's my interpretation.
Okay. And essentially, that constitutes manufacturing a drug product.
You would need a new drug application. You would have to follow CGMP guidelines and specific labeling information.
Okay. In your professional opinion, should a prudent and reasonable pharmacist compound drug products in conformance with FDA guidance?
In my opinion, yes.
And in your opinion, a prudent and reasonable pharmacist would follow the FDA guidance on inclusion of a statement of significant change documenting a medical need specific to a patient through the inclusion of a statement of significant difference.
In my opinion, yes.
Okay. So in your opinion, does a pharmacist that fails to follow FDA guidance when compounding drug products, have they performed their duties in an incompetent, unskillful, or negligent manner?
Could you repeat that question?
Sure. So a pharmacist that fails to follow FDA guidance, let's say this FDA guidance, Exhibit E, excuse me. A pharmacist that's compounding drug products that fails to follow the guidance admitted as Exhibit E, have they performed their duties in an incompetent, unskillful, or negligent manner?
They would be subject to the exemptions, which I think then would probably qualify for the statement that you just mentioned.
But if they fail to qualify for the exemption because they failed to include a statement of significant difference, is that incompetence or unskillful or negligence?
I would say yes.
Okay. By changing that inactive ingredient from peanut oil to olive oil and not documenting as medical needs specific to the patient for the change, would you consider that a circumvention of federal law?
I would state that they're not following the guidelines, which would then exclude them from the exemptions, which would then be violation of the law.
Okay.
If that
In
makes sense.
absence of the documentation of the medical needs specific to the patient on these prescriptions in question, in your opinion, was the respondent manufacturing essential copies of progesterone 100 milligram and 2 milligram capsules?
Yes.
Okay. I have nothing further for the witness this time.
Mr. Ballo?
Yeah, Mr. Dodge, I'd like to look at Exhibit A real quick.
Sure. Got it.
Before you begin, Mr. Ballo, could you move the mic a little closer to the mic? Thank you.
I'll move closer. This, on page 1, is this the list of the 28 prescriptions that issue?
Yes.
And the commercially available strength for progesterone is 100 and 200?
Correct.
And some of these, looks like 11 of them are for strengths that are not commercially available. Is that correct?
That's correct.
So would those be considered essential copies?
They would not.
But looking at Exhibit E, over very thoroughly. If we look at page 1, second paragraph, that first sentence there, it does state. Can you read that for me?
Absolutely. In general, FDA's guidance documents do not establish legally enforceable responsibilities.
So is it your understanding that this document is guidelines only and not enforceable law?
It's my interpretation that these are guidelines, but once again, if you don't follow the guidelines, then you can't qualify for the exemptions, is my interpretation.
And these prescriptions were prescribed by doctors, presumably after consultations with patients, correct?
I would assume so, yes.
And also you'd assume that the doctor had a reason for prescribing this particular formulation, correct?
Potentially, but I don't know for sure.
Um, With, aside from allergies, is there any other reason that you know of that a pharmacy may compound with olive oil?
I'm not aware.
Did you review any of the documentation sent by Ms. Thron in response to requests by Schubert? Schubert,
The clinical information, is that what you're referring to?
yes.
I did not.
Okay. Are you aware of any health benefits that are associated with using olive oil instead of peanut oil?
I am not.
Page 8,
Of Exhibit E?
I think, yeah, stands as the guideline. You had testified that, according to these guidelines, pharmacy needs to include the statement of significant difference with the prescription, right?
It states in the guidance that it should be listed on the prescription, and then it contemplates if it wasn't, that the pharmacist could contact the practitioner.
Okay, that's what I wanted to focus on. It specifically states should, right?
Correct.
So again, not a requirement, a recommendation.
Recommendation, they give two different options for doing it, but once again, if it's not included, I would refer back to the fact that you can't have the exemptions if it's not included, is my interpretation.
Under these guidelines, is it your opinion that progesterone with olive oil instead of peanut oil is a copy, an essential copy?
If the information for the significant difference is not listed, then it would be an essential copy from my perspective.
I mean, people with olive oil.
Correct, correct.
And just final question. Front page of this exhibit lists the date it was published. It's January 2018.
Correct.
You know when prescriptions that issue of this matter were issued?
I believe that's probably part of Exhibit A. It was 2022, 2023, I believe.
You know whether this guidance document was the latest version in 2022?
I believe this is still the latest version.
I have no further questions.
Thank you.
Mr.
I
Knapp,
have no further questions.
board members, any questions for Mr. Dodge? Thank you, Mr. Dodge.
Thank you.
Any other witnesses, Brett? Any other witnesses?
I have no other witnesses and at this time, no further exhibits to present.
All right, I'll turn it over to Mr. Ballo.
Okay, do you have a 5-minute break?
Okay, we'll take a quick break. We're back on agenda item 5D for Wells Pharmacy, and I'll turn it back to Mr. Ballo.
Yeah, Wells would like to call Melissa Stepko, witness.
Public, please.
Feel free to tell me if you can't hear.
All right, and just as a reminder, Ms. Stepko, you're still under oath.
Okay, Ms. Stepko, you've reviewed the complaint and the exhibits. And what's your understanding about how many prescriptions are involved?
I believe the list had 28 listed, but it appears that several of them don't, as we've heard, don't match the guidance to or meet the criteria of copy. So there are a few that are 50 milligrams, a few that are 25 milligrams, which are not commercially available.
And the list is on exhibit A on page 1. And can you tell by looking at this list how many would not be considered essential copies because of the dosage?
That's around 12.
So we're dealing with 16. Here's my math. 16 prescriptions over the course of over a year.
Yes, 13 months.
Aside from the issues we discussed before, where documented need based on an allergy or some other health situation for a particular patient, are there any other reasons why a compounding pharmacist may be able to prescribe what would otherwise be an essential copy?
Yes, you can make essential copies during drug shortage.
And how would a pharmacy determine whether a drug like progesterone was shorted?
There are 2 lists that pharmacists typically use, competitors use. There is the official list that FDA prefers to use, which is the FDA drug shortage list. There is a more accurate list. We feel more accurate as an industry. The ASHP list, which is more real-time data that you get more quickly. And it's a little bit more nimble than getting on and off the FDA drug shortage list.
Just for everyone, can you tell us what AS?
Would love to if I could. Association. Hospital pharmacies.
You know what it is.
Yeah, I know you know what it is, but I can't remember the acronym. I'm so sorry.
It's an association of hospitals.
Yes.
Okay.
Yeah.
And do you know whether progesterone has been on either of these shortage lists?
Yes. The ASHP list several times. It's currently on the list.
Okay, so it's currently on the list. So you would, Wells or anyone else would be able to currently compound progesterone in a commercially available dosage without any statement required. Is that correct?
I suppose that would depend on who you ask. So FDA does prefer you go by the FDA drug shortage list, but like I said, it doesn't move as quickly. Their data is compiled a little bit differently. So ASHP, I feel, is a more of a heads up that it's currently happening, than an FDA hopefully usually follows suit. I haven't seen them follow suit on progesterone, but it's been on the ASHP list multiple times over the several years. And currently, there's drug shortages with the pharma companies that are currently making them, and it's self-reported by the drug company.
Okay, and what's your understanding of the FDA guidance document that is in Exhibit E?
The FDA guidance is FDA's thinking around a particular topic. From the discussions with FDA directly, they admittedly, it's not an enforceable document. It is their thinking around it, but it's not something that I've seen where enforcement action has come about because of the guidance document.
And prior to 2022, 2023, had the FDA inspected Wells's facility that compounds the progesterone?
Yes.
And did Wells pass that inspection?
There isn't a pass-fail. We did have one observation, but it's not related to this.
Did the FDA raise any concerns with Wells's compounding of progesterone?
No.
Did they raise any questions or concerns regarding the lack of inclusion of a statement of significant difference in any products compounded by Wells?
No.
And since this time, can you tell us about how Wells operates, any changes it has made to ensure compliance with the guidance?
Yeah, so as we stated earlier, we heard earlier that we ceased compounding the 100 and 200 milligram back in 2023 when this was brought to our attention. In addition, we have a lot of stopgaps in place. We've of course changed. We talked a little bit about changing over of the supervisory and management. We have updated our pharmacy software system to provide some stopgaps. And we have a better process of looking at the drug shortage listings and a better understanding around the drug shortage listings and which one does help provide those exemptions, which is the FDA drug shortage list. And we have other policies and procedures that were updated as well to ensure that this thing is correct.
And do you know when progesterone is on a shortage list? Do you know the reasoning behind why Wells would be able to compound progesterone and ship to a patient? Is there a specific, patient safety issue or need that's addressed that is?
Yeah, so FDA allows compounding of essential copies during drug shortage to alleviate the shortage in the industry to ensure that patients are still getting their medication. So they don't want to have, they've expressed that they are big supporters in continuity of care and continuity of the therapy between the patient and the physician. So this would be one of those instances.
Okay, and are you aware of any safety issue that would apply to patients if a statement of significant difference was not included?
No, this is purely a documentation oversight on our part. There was no safety concerns or complaints or adverse events around this product.
And again, as far as the guidance is concerned, are you aware of anything within that guidance that states that failure to follow it would constitute a violation of a forcible regulation or law?
No, it says the opposite.
So is there anything like that?
Right, let's turn it over to Mr. Pant for cross.
Just two quick questions, Brett Camp for the record. And you've got copies of what's been admitted into evidence exhibits A through E. And in reviewing the communications between the board and Wells Pharmacy, was there any indication in there that these compounded products were addressing a shortage?
The shortage was not indicated in this.
And then secondly, reviewing the FDA guidance, is there any provision in there about that the inclusion of a statement of significant difference isn't necessary in the event of a shortage for the compounded drug product?
I would have to read that particular paragraph, but from my top of my head, it says that this does not apply in the event of a drug shortage. This guidance does not apply.
It does say that in there?
I don't know if it says that specifically, but from the top of my head, that is how I remember interpreting it.
I'll ask you just a follow-up if I can, David's to help you, and I can tell you very well. Is it common industry practice that when there's a shortage, that gives the ability of 503Bs and 503As to compound those products? I mean, we are aware that is, wherever it is, that is what the FDA says. Is that what you're saying?
Correct.
Okay.
And I'm not aware of additional documentation required other than it's good practice to keep record of the drug shortage list because it's not something that you can easily go back and look at. You can only screenshot it from anybody that I've spoken with, and that's one of the changes that we made in our facility.
Can I do a follow-up, please? So, I think the board is aware they're pharmacists for the most part, so they're aware of the shortage date, at least for the record. So is there any, I think what you're trying to point out that there's other things that have happened, that could happen, that could do that, but you're not necessarily saying that happened in this case. Is that correct?
I wasn't an employee at this time,
Perfect.
so it's hard to
You wouldn't
say.
be in a position.
Right.
No problem. And I could, is there, do you know if there's guidance? I'm just trying to set the record straight. I think the FDA goes by the FDA list. They don't recognize, I'm aware of it. Is there any guidance that you know of today that says you can use the ASHP guidance in lieu of the FDA, from the FDA?
Yes.
Okay, and then, just to tackle the FDA and the guidance and the essential copies. You're probably in a position to watch what the FDA does because you're interested in it.
Yes.
But would you be in a position to know everything that the FDA says or does? So could there be a case where they have done an essential copy or been given a notice of an essential copy to somebody that would be related to the guidance? And you would not know about that, or do you know everything that the FDA does?
A notice or enforcement action, because those are two different.
A notice for an enforcement action.
There have been notices, but there haven't been any enforcement actions.
And what's the purpose of them doing a notice, in your opinion?
To ensure that they.
To identify the people that they're concerned about.
Yeah, yes.
And then, just because you brought it up, your 483, what was the observation on that, to your knowledge? If you know, you might not be, but you brought it up, so we
Yes,
want to know.
the water system wasn't tested for burglary.
Thank you, appreciate it.
So just to follow up, once again, Brett Camp for the record, I would ask you to look at Exhibit E, and you're correct, on page 9. There's a subheading, documentation of shortage. It's pretty short. Could you just read that for us?
If the drug was come back because the approved drug product was not commercially available because it was on the FDA drug shortage list, prescriber or the compounder should include the notation on the prescription that it was on the drug shortage list and the date when the list was checked.
Okay, and then looking at the prescriptions in question here that are Exhibit C, did you identify whether the notation appears on each prescription that the drug is on this shortage list and the date it was checked?
No.
Is that information contained? It's not. Okay, and then, I'm sorry, I talked over you. Go ahead and answer the question.
It's not on the.
Thank you. And then also looking at that paragraph in the FDA guidance Exhibit E, is there any indication that in those circumstances where the documentation of shortage would apply, that is in lieu of a statement of significant difference?
I don't believe it's clear.
Okay. So would it be fair to say that even if prescription includes documentation of shortage, it could also include a statement of significant difference? They're not mutually exclusive.
I'm not an
I have no further questions.
I asked just a couple. Oh, go ahead.
attorney. No, certainly.
Go ahead.
Go ahead.
Back to the page 9, the documentation shortage. It says the prescriber or compounder should include the documentation, not required. And again, on page 1. The end of the second paragraph. It says. The use of the word should in agency guidances means that something is suggested or recommended, but not required. Correct. And that's it.
Yeah, anything on recalls? Board members, questions for Ms. Stefko?
For the record, Stefko, so is it your testimony that progesterone capsules were on the ASHP shortage list at the time that these prescriptions were filled?
It's not my testimony. My testimony is that I know that it has been on and off the list of ASHP. I know it's drug shortage list, and it's difficult to go back and once things come off, they're Really isn't a lot of traceability back to 2020.
Okay.
I'm Helen Park. So could you, I know you said your title in the beginning, sworn in, but could you review your title and your role in this case?
Senior Vice President of Regulatory. I did work for Wells previously. I had a child, so I took a year and a half off. And came back, and this occurred during that time.
During your absence?
Yes, but I'm currently overseeing regulatory quality of the company.
And then are you a pharmacist in your?
I'm not,
Okay.
no.
All right. Do you happen to know why the information or a statement of significant difference was not included on the prescriptions as a practice?
I don't, but I speculate that we have thousands of prescriptions per day, and it's just a clerical error. We have very manual processes in place. Fortunately, it's not as clean as it would be in a pharma company. It's something that we're definitely working towards, even as an industry, to get some more automation put in place to avoid issues like this, but 12 or 16 over 13 months, it's a very low number in the grand scheme of how much we actually do for business. And I imagine it just slipped through the cracks, unfortunately, and it's something that we've subsequently addressed.
You do acknowledge that it happened, but feel that it's pretty significant based on your volumes?
Statistically, yes, but in terms of regulatory impact, it's something that we do take very seriously.
Okay, and you mentioned a number of changes that Wells has gone through. Is this something that is now included on prescriptions?
Yes, yep.
Okay, and then for those approximate 16 that occurred over the 13 months, do you, in your opinion, believe those prescriptions were essentially copies?
I can't say because I wasn't part of the patient prescriber relationship or the visit, so I wouldn't be able to say that.
Okay, and then you may
But I
not
do
be able
think-
to. Oh, sorry, go ahead.
But I do think there was a documentation error, yes.
Okay, to your knowledge, and again, I go back to what you just said, are you aware if the patients in this case, the 16 prescriptions, did they have allergies to peanut oil, to your knowledge?
I'm not aware, I haven't investigated that.
Okay. And then why, to your knowledge, why did Wells Pharmacy cease production of the progesterone 100 and 200 milligrams in 2023?
I wasn't there, so I can't say. I just know that it was done.
All right, and then the last thing, I think this is what Mr. Horath was getting at, but you testified earlier that drug shortages could be the reason, another reason for compounding, but you're not saying that that's necessarily what happened in this case, correct? Thank you. Board members, any other questions?
Ask one follow-up. Okay, as far as the statement of significant differences and medication and drug shortages, who's responsible for putting that on a prescription? Is it the prescribing doctor?
I think it depends on who you ask. It is the doctor's ultimate responsibility, but the board regulation feels that it's the compounder's responsibility to ensure that it's on time.
Okay, and what does Wells do now if it sees a prescription without requiring a patient on it?
We contact the physician.
Mr. Cat, anything else that you want to ask? Okay, and I'll give the board another opportunity. Anything further?
Well, I do have a question.
Okay.
Dick Tomaso. So what would
Dick, can you explain who you are for the board? So they know they don't know you.
Because I'm not a pharmacist. What would be the reason when the Wells compound, this drug. Well, why didn't they just use peanut oil if that's what everybody thought they were gonna get? Peanut oil in the drug. But why would they change it to olive oil?
Because compounders don't make commercially available products. So the commercially available product is with peanut oil, so that can be commercially purchased. And it was not drug shortage.
Oh, so then all the prescriptions that were written that you filled, they expected olive oil and not peanut oil.
Correct,
That's what you're saying?
correct. We would only make it,
Because you couldn't make it with peanut oil.
correct.
See, I didn't know that.
It's not fun. It's just bad, brother, just, we don't need to break. We lost you on camera for the public, we still have your testimony and everything. I think it's not getting out. Yeah, okay. I just want to get you back. People want to see your appearance. We can see. Thanks, Darrell. Sorry, Madam President, technical issue.
Mr. Tomaso, any further questions?
No, thank you.
Thank you, Ms. Stefko. Mr. Gallo, any further witnesses?
No. That's it.
Then we'll go ahead and move to closing.
Greg Camp for the record. So once again, referring to the charges in this case, there are one charge is based upon the disciplinary action taken against the respondent by the Missouri Board of Pharmacy. That forms a basis for discipline under NRS 639-210-12 for the failure to follow or violation of the laws of another state regarding the practice of pharmacy. And then with regard to the prescriptions in question here, I think the evidence and the witness testimony supports the allegations. I think in two respects. One, I respectfully submit that the failure to follow the FDA guidance is unprofessional conduct, that a reasonable and prudent pharmacist would follow FDA guidance when compounding drug products. And two, if we could quibble about the legal status of the guidance, but the fact of the matter is a pharmacist's not following the guidance and is in fact, as in this instance, changing an inactive ingredient, the peanut oil to the olive oil, without documenting the medical needs specific to the patient for the change. They're circumventing federal law. They're circumventing the requirements of 21 U.S. Code 353A, and they're manufacturing essential copies of the drug and don't qualify for the exemption. So that alone would constitute a violation of federal law. If you're circumventing the requirements of federal law, that would constitute a basis for discipline under NRS 639-210-11. And certainly, once again, if you find that a reasonable and prudent pharmacist would follow FDA guidance when compounding, that would constitute unprofessional conduct and form a basis for discipline under NRS 639-210-4. And on that basis, I would once again ask you to find the respondent guilty on the single count.
Mr. Gallo, your closing arguments?
Yeah, I'd like to start with Missouri. We do think we had a violation of Missouri. We submit that any action here would just be duplicative of the probation already received in Missouri. As far as the progesterone issue here that was shipped into Nevada, again, we contend that there's only 16 strips at issue and not 28 as alleged in the document due to the difference in strength. And we do not agree that the statement of significant difference is required. It's clear that this is guidance. There's nothing in the regs that state you must follow the guidance. We're unaware of anything that says failure to follow this guidance is negligence on behalf of a pharmacy or a pharmacist. The statement of significant difference is not required in the regs. There's no law requiring it. We are unaware of any FDA enforcement actions that have been taken against anyone for failing to include a statement of significant difference. So again, these are recommendations. They are followed now. We do take it seriously, but again, this is a needle in a haystack of prescriptions that have gone out over this time. It's statistically insignificant, although it is significant, but minor clerical error led to this. So we'd ask for leniency on this, and that would be yes.
All right, thank you. So with that, we'll move to board discussion.
I just have a couple comments. Also brought up Missouri. In Missouri, that they were already disciplined in Missouri for this. But yet, I only bring this up because you mentioned Missouri. I see here, reading the discipline in Missouri, it says that 4 compounds of this progesterone, and olive oil, 100 and 200 milligrams. It says respondent acknowledged that those 4 did not have details documented properly, and that they did not contain documentation on the prescription record of medical needs specific to the patient for the compounded product. So you actually says, yeah, we were wrong. You admitted you did in Missouri, we did here. You said in Missouri you were wrong. Well, you're saying you're not wrong. And the fact that you're asking for leniency, you're not denying any guilt. But even, let me take one last thing I want to comment on is that you keep going back to this. Exactly where you say that it doesn't say, the reg doesn't say you must do this. But the way I see it, because Mr. Dodge read other paragraphs from it, that you're taking it out of context. You took some parts of this there that seem to make it sound like you didn't have to follow any of this. But yet when Mr. Dodge read the other parts of it, it showed that because you didn't get the exemption, that you didn't have to document the prescriptions. So he added more to what you did. You just stopped short of what he testified to. So my feeling is that you were in violation, and you did violate. I'm talking to the board also, that they did violate that count because they did act unprofessionally and so that's my opinion, just based on those. It's just simple things right there. But again, I'm saying it from a public member, I'm not a pharmacist. These people promote products in their careers so they could speak more intelligently about it than I can.
Thank you, Mr. Tomaso. Mr. Bora?
Adam Forth for the record. I think it's important to remember why creating an essential copy is an issue. There's 2 reasons why we wouldn't want to do that. Number one, there's an inherent risk to compounding something that is available commercially. When we are compounding in a setting that is not meeting the standards of a manufacturer, that is more risky than if you bought a commercial product and provided it for a patient. So the trade-off has to be there, that there's a benefit to offset that risk. And if you're not documenting that there is a reason that it's not essentially a copy, either that there's a significant difference for that individual patient or that there was a drug shortage going on that time, then you're in violation of federal law. And so I think that, I just want to clarify, there seems to be a question, by my count, there are 17 prescriptions in Exhibit A that there is insufficient evidence to suggest that they are not essential copies. And so I would agree that for those 17 prescriptions, there was a violation of law.
I agree that by not following the recommendations, that they were no longer eligible for the exemption. So, and this might be an omission and not intentional, but because they didn't document accordingly.
No, just a few comments, Crystal Freitas for the record. Missouri found them in violation of the same thing, a commercially available product, and they were compounding it. So I don't think that there's any question with that. We're finding it for the same thing for the Nevada patients and Adam's count is correct, 17. So whether or not it's a significant amount or not is not relevant to me. It happened. And then FDA guidance, even if it says should, it's FDA guidance. They regulate a lot of things in our industry. And so I would feel it is best practice to follow their guidance.
Okay. I'll add a couple comments as well. So I think it's pretty clear, it's not disputed by either party that that in 16 or maybe 17 cases, the products were shipped to Nevadan patients and they were essential copies. They have said that they've made those changes, and so now they're following the guidance. I feel that they are in the beginning not recognizing the guidance and now recognizing the guidance, and so they are aware that they should be following the guidance. But it still goes to the fact that they did not follow federal law. They violated federal law, that these were essential copies, that there were no statement of significant difference. It did happen in Missouri, but it also happened in Nevada. So it's not just a reciprocal action. This impacted Nevada. So I think for all of those, to me, it's clear this happened. Perhaps they weren't aware at the time, but now they're aware. But regardless, it happened and they were essential copies and it was a violation of federal law. And that constitutes, all of that constitutes unprofessional conduct in Nevada. Those are my thoughts. I'll open it up to board member Anna Carr or
Dr. Taylor, I think we lost, but we'll just mark that for the record. I was gonna bring it up in the call, so maybe Anna wants to say something. And if Janice is there, she can speak, but I don't think, I think we lost her part.
Okay.
So we'll make the record will show that.
Thank you for the opportunity to speak, Anna Carr, for the record. I don't have any additional comments that haven't already been said, other than I also agree that I believe that these were essential copies and the violations are pretty evident and apparent in this case.
Thank you. So with that, are we ready to move? Motion?
So just procedurally, the board will make a motion, they'll find facts or not find facts. There'll be a pause there. If they do, if it's not guilty, then you'll go on your way. If it's guilty, then there'll be the what the difference will be, and then staff will probably make some recommendations and you'll be given the chance to talk about those.
The findings of fact.
Question for Todd. Is one of our findings of factor different from what's within the allegations? Because we're determining that there were 17 prescriptions versus 28. Do we just omit paragraph 2 from the factual allegations altogether? Or?
Yeah, right, senior data count was, yeah, the facts can be, the board's finding the facts can be amended to whatever the board's findings are. It doesn't have to be word for word what is in that complaint. So when you vote on the findings of fact, you can vote to, find find the paragraph 2 with the amendment 17 versus 28. That should be sufficient.
Jacobo, I move that we make findings of fact consistent with paragraphs 1 through 3 of the accusation, amending paragraph 2 to read 17 prescriptions rather than 28.
I have a motion by Mr. Kobo, a second by Mr. Porath. Any further discussion? Hearing none, all those in favor?
Aye.
Any opposed? Okay, that motion carries.
I move that we find conclusions of law consistent with paragraphs 4 through 9 of the accusation.
Second.
Motion by Mr. Kobo, second by Mr. Porath. Any further discussion? All those in favor?
Aye.
Any opposed? Okay, that motion carries.
I move that we find respondent guilty of count 1 consistent with paragraph 10 of the accusation.
Second.
Motion by Mr. Kobo, second by Mr. Porath. Any further discussion? All those in favor?
Aye.
Any opposed? Okay, that motion passes.
Ready for this one topic. I'm gonna do this because Brett and I discussed this before every meeting, I think at least for the record, but I think we've seen some things today that has caused me to modify what I think staff was going to present to you for the penalty. And so I'd like to do that myself, if you will, in a couple actions.
Certainly.
So I think that, I'm not gonna get into merits of the case, you've already found that. And so just for the penalty phase, I think some things that they presented today, that have meaning to board staff is one, they were licensed with us in this day and age where I'm seeing more and more people not even licensed with us and doing this. I think, that is a mitigating factor for staff. The fact that they were honest and open with us when we asked for records and they provided that, that's mitigating, and we don't always see that, and you've seen hundreds of cases and you know how that is. So I think that's a mitigating fact. And I think that, I mean, you can do different kinds of fines, but I would ask you that in lieu of doing a large fine, that we could go inspect if they want to continue to operate in Nevada, that we could send staff to go inspect if they're willing to accept that. That is normally at their cost. And then you can leverage that over with the fines. And of course, a reasonable attorney fees and costs would be the other thing that we want. So I don't really have a dollar amount to give you that we would be looking for, but those are the things that board staff would just point out. And I think, you know, I think Nevadans need these types of products in certain circumstances. And so and I also want to say, like, we were thinking probation and state revocation and that kind of state suspension or those, but they're out of their probation with Missouri. And so you maybe leverage, you know, they don't have to be on probation for you to tell them what to do, but that would be one of the things. If you want them to be on probation, the only way you can do that is like take a suspension and then stay that suspension. So that would be for you to decide. And Brett can add anything else that I didn't cover. I did get fees, Brett, and costs.
Yeah, and then Brett Camp for the record, in terms of attorneys' fees and costs, opposing counsel and President Park, you have a copy of a memorandum of attorney's fees and costs that are recoverable pursuant to NRS 622-400 that's been compiled by myself and staff. So I know you're going to ask counsel if they've had a chance to review that. Assuming there's no issue, I would ask that that be admitted into evidence as Exhibit F.
Yeah, I already reviewed it. I don't have any objections.
Ready, and so admitted as exhibit F.
And then I would ask their counsel or whoever wants to speak on their side, if they want to say whatever they want about the penalty phase.
Yeah, I'd ask that, if there is a penalty involved, that it not include probation. I believe we're open to having an inspection with that. That's something that we welcome, ensure that everyone's happy with how we're operating and we're operating correctly. So we just ask that it's done.
their probation. Hopefully, not a large fine.
Thank you. And I'll turn it back to the board.
There, it's my understanding, and just because I would have heard if there was, no patient got harmed by any of this, am I correct about that, or would we have?
No record of that, Dick. We did not present evidence of that effect.
And I tend to agree with our executive secretary. That the $3,000 something for the cost is pretty strong, and the inspection is also gonna cost some money. Is that right? The way it works for our staff?
It's just a direct cost pass through to them.
Right.
So whatever it costs us to do it. We normally send 1 or 2 people.
I'm not opposed to lower fine. They did fall under sword. I mean, they put up, the only defense they had was to say that it was a suggestion and not a rule, but that is the best they had. But other than that, they kind of said, yeah.
I agree with
Mhm.
Mr. Fossil. They've taken the subsequent remedial measures. They have admitted that they probably should have. And then just giving them the benefit of the doubt that if there were patients that indeed had a peanut allergy, they were doing it for the patients.
Okay, so I think I agree with some of these statements. I think I like the idea of inspection. I'm glad to hear that Wells Pharmacy is open and welcoming to that. I think that will alleviate any concerns that we have in regards to whether or not they're in compliance or following a law or being, their safety to Nevadans. I do think in terms of a fine that, a smaller fine would be appropriate. I would be comfortable with $5,000 or $2,500 as a fine in addition to the fees for the fees and costs associated with the case. And then again, the inspection at the cost of Wells Pharmacy.
I feel like 2,500 is kind of steep, but that's just my personal opinion. Happy to hear what the rest of the board thinks.
I don't think that's too steep, Adam Porth for the record. I mean, I think if you said, in my mind, I was thinking $500 per prescription. So that's a lot more than $2,500. So I'm fully supportive of 2,500.
Let's try to minimize it.
Yeah.
But, yeah, okay. Any other discussion on that?
No, I think, sorry, Crystal Freitas, I think either way, like 500 per prescription does seem a little steep, but 2,500 sounds okay.
If we're gonna put that on the table, then yes, I will agree with the 2,500.
Yeah, I mean, at the end of the day, they were found guilty of one charge. And so Adam Porth, for the record, I would move that we fine Wells Pharmacy $2,500. I would move that the memorandum provided attorney's fees and costs that were reasonable, necessary, and actually incurred, and that we would charge the defendant those costs in the amount of $3,884.85. And that they would be inspected by board staff at
Yeah, in the next 6 months or something like that. That is just so we can arrange.
within the next 6 months at the cost of the defendant.
Second.
Okay, we have a motion by Mr. Pora, a second by Ms. Jacobo. Any further discussion?
I always remember the reasonable necessary, actually correct. I remember RNA like DNA, but it's ribonucleic, sorry.
Any other discussion? All those in favor?
Aye.
Aye.
Any opposed? Okay, that motion passes.
So the record will state that Dr. Taylor did not vote on this, so to the record.
That concludes this matter. Thank you for your time today and.
Lunch break.
We'll break for lunch. Back up front. All right, so we're gonna continue with our Board of Pharmacy meeting agenda. We'll go to agenda item 5R next with Mary Southard. Mary Southard, any representatives, please come forward. If not, Mr. Sedino, are you ready to proceed?
I am.
Before you do that, Greg, we've moved, because we're moving along, so we've moved some people from tomorrow for today. We have one in person. There's 2 or 3 that are on the line. We have to just do a couple more hearings, and then we'll get to those people so that they know who we haven't forgotten about.
Thank you, Madam President. For the record, Greg Zanino. Handling this for board staff. This is the matter of Nevada State Board of Pharmacy versus Mary Ann Southard, pharmacy or pharmaceutical technician, case number 22464 PTS. The accusation in this case begins at page 2935 of your board book. The allegations against Ms. Southard are fairly straightforward. She was convicted of an offense involving dishonesty. She disclosed on a renewal application that she had been arrested, but she did not disclose that she had actually been convicted. Separately, because she was convicted of a offense involving dishonesty, that's grounds for discipline as well. By statute, because Ms. Southard has failed to appear, you can find basically that she's admitted to the allegations in the accusation, provided that we establish that she was properly served with notice of today's hearing. With respect to service, there is a declaration of Gisette Fenaricone that appears at page 2944 of your board book. This takes the place of live testimony. This is essentially if Gisette were to testify, she would testify to the following, and she would to the things that were stated in the declaration, specifically with regard to Exhibit 1, beginning at page 2946. She would testify that she signed this document, that she served it, that this was accompanied the notice of hearing in this case, and that was mailed via certified and U.S. mail to 2 locations. Both of those were the most recent addresses that we had on file. With regard to Exhibit 2, these are the certified mail numbers, the tracking numbers that were assigned to each of the parcels that were sent to Ms. Southard. Exhibit 3 is the USPS tracking information. And you see that one of these parcels, I think perhaps even both of these parcels, were delivered to the addresses that we have on file. Finally, we have at page 2954 of the board book a memorandum of costs, which indicates that the board incurred a total of $757.41 in costs in terms of investigating and preparing this matter for hearing. So with that, I will make, well, first I'll move to admit exhibits 1 through 3.
So admitted.
And then secondly, I would recommend that you make findings of fact. Well, let me backtrack. First, I would ask you to make a finding that Ms. Southard was properly served with notice of today's hearing. Additionally, I'd ask you to make findings of fact consistent with paragraphs 2 through 6 of the accusation. I would ask that you make findings of law consistent with paragraphs 7 through 10, that you make findings of guilt consistent with paragraphs 11 through 19. And then with respect to the punishment or discipline to be imposed, I would recommend that you revoke the certificate of registration retroactively to October 31st of 2024, which is the last date that that this respondent actually held an active certificate of registration. I recommend that you impose a fine of $500 if to be collected if and when the respondent petitions for reinstatement. And I would recommend that you impose costs of $757.41 to be collected if and when the respondent petitions for reinstatement. And finally, I would ask that you find that the costs were reasonable, necessary, and actually incurred. I know I covered a lot, and I'm happy to go back and cover anything a second time if you like.
Helen Park, so moved. Second by Mr. Hobo. Any further discussion? Okay, hearing none, all those in favor?
Aye.
Any opposed? Does that conclude that matter, Mr. City?
It does. Thank you.
Thank you. We will move to agenda item 5A for Ajimobi Charles Abu. So Dr. Abu or representatives are here. Forward. If not, Mr. Kent, are you ready to proceed?
Greg Camp for the record, prosecuting this on an order to show cause. This is case number 22-535-CS-S. The respondent, Ajimobi Charles Ogu, MD, certificate of registration number 21324. Once again, this is an order to show cause and a short cause hearing. Brought on the basis that the respondent is in violation of the March 6th, 2024 board order revoking his certificate of registration and imposing discipline. And that respondent has failed to make payment of fines totaling $5,000 and to pay $4,065.51 in recoverable attorney's fees and costs. I am, in the respondent's absence, prepared to provide evidence into the record that the respondent was properly noticed and served with the order to show cause and notice of this hearing today. I'm just going to pass these around if that's okay. In the form of a declaration. In the form of a declaration from board staff and a couple of accompanying exhibits. The first exhibit demonstrating proper notice of the order to show cause in conformance with Nevada law. And then the second exhibit demonstrating proper service of a second notice of this hearing today in conformance with Nevada law. I'd ask that those be entered into the record. And the board can note that the service of those documents occurred to two addresses. One was the respondent's practice address, last address of record with the board, in which service was attempted but unsuccessful, but also service to the respondent's residence. In that instance, service was successful. An individual in his residence received service. So with that, I am prepared to ask the board to make specific findings of fact and conclusions of law. Because we're on a show cause order, really, I just need the board to make a finding that the respondent has failed to comply with the board's March 6th, 2024 order and failed to make payment of the fines imposed in attorney's fees and costs. And then also that the respondent was properly served in notice of the show cause hearing.
So Mr. Kent, just to clean up, so I will admit exhibit 1 and exhibit 2 And then with the declaration, that would be exhibit 3. Okay, so exhibit 1 through 3 be admitted to the record.
Sorry, Mr. Cant, can you repeat
Sure.
the motion?
Sure, I think simply I'm just asking the board to make findings that the respondents in violation of the disciplinary order through non-payment of the fines and the attorney's fees and costs, and that the respondent was properly noticed of this show cause hearing today.
So moved.
Crystal Freitas, second.
Motion by Mr. Cobo, second by Ms. Freitas. Any further discussion? All those in favor?
Aye.
Aye.
Any opposed? That motion passes.
And secondly, because the respondent failed to appear at the show cause hearing, you could deem that a waiver of the respondent's objection to any proposed action. And so because the respondent's already been revoked, really the only action would be to find him in, you found him in violation of the order. And so non-payment can result in referral to collection through the state controller's office. So that's all I'm asking.
So moved.
Crystal Freitas, second.
We have a motion by Mr. Cobo, second by Ms. Freitas. Any further discussion? Any all in favor?
Aye.
Any opposed? Okay, that motion passes. Thank you.
Nothing further.
May I ask a question about this?
Certainly.
I know it's closed, but if we already revoked his license, when we revoked it, was it just, it's revoked, ad infinitum, and so we can back, or what, or was there a limit on it or anything like that?
Brett Camp for the record to answer Board Member Tomaso's question. So whenever you revoke somebody's certificate or license, you have to prescribe a period before they can apply for reinstatement. And the law provides that it's got to be a minimum of 1 year, but it can't be for a maximum more than 10 years. So you can't really revoke them forever. The law doesn't contemplate that. So in this instance, he would still have to petition you for reinstatement after the prescribed period to seek his controlled substance registration. Or alternatively, he could apply for a new controlled substance registration. But in either instance, the authority whether to grant, reinstate a registration or to issue a new registration lies with you. And so you certainly could take into account a non-compliance with the past board order if that ever occurs.
Well, here's what I'm thinking, just to think out on, just for future. If this it happens again and someone, we revoke them for a period of a year. And then this happens.
You don't revoke for a period. This is a very important distinction in the law. A revocation isn't for a specific period. A revocation is, it's revoked, but then you have to prescribe a period before which they can apply for reinstatement. A suspension is for a specific period, but they're actually, they operate differently.
Okay, so if we give him a period for the revocation, he has to wait to apply.
Before they can apply for reinstatement.
Making this up, let's say we did 3 years.
If they come to you before that period is passed, they can't come to you and ask for reinstatement sooner.
Okay, so then why would
If you say you gotta wait a year, they gotta wait a year. They can't come to you sooner. If you say they gotta wait 10 years, they gotta wait 10 years. They can't come to you sooner.
Okay, so rather, I mean, besides sending this to collections, why would we say, well, if we said 3 years last time, now it's 6? Why wouldn't we just add to the, has to wait to come to us since he didn't comply? What's the thing? Why is it just to add, send it to collection? Why can't we take another?
Well, you can only take a revocation action in strict conformance with the applicable statutes, and that's the way they read. They limit you in that regard. And so that's just the way they operate. But once again, to the extent this respondent ever wanted to obtain a registration with the board again, they're going to appear before you, and ultimately it's going to lie with you, and you can take into account their past violation or failed to comply with the order.
If he ever comes back at that point. Reevaluate and continue.
Well, this thing, this seems, this is for the board's information, this seems like we should have just sent it to collection rather than go through all this hearing, just send it to collection. If all we could do is send it to collection, why bother doing this? Why don't we just send it to collection? I thought maybe we could revoke it for, or tell them the period, now you can't come back for 10 years before now because you didn't comply with this, but if we can't do that.
Yeah, Dave, it's a very fair question. The reason procedurally we do it this way is because that's what the law provides, that if somebody's in violation of the board order, that we issue an order to show cause. And we give them, it's a due process issue that board staff doesn't just decide they're in violation of an order. We have to notice them and bring them before you, alleging that they violated the order. And then if you find that they violated the order, they've been given due process and opportunity to appear before you and contest that they violated the order. And if you find they violated the order, then they've been given due process and you can take further action. I now understand in this instance, what further action is there to take? You already revoked him. But it's still important because this order you're issuing today, finding him in violation, that's also going to get reported to the National Practitioners Database and is a public document, just like the original order of discipline was. So it is important because now it's a public record that the respondent not only was revoked a year ago, but then didn't comply with your order. You know, that's been made a public record now. Does that make sense?
Yeah, thank you. Okay, all right.
All right, so we're gonna move to our next agenda item, which is 5U for Quasha Felton. So Quasha Felton, if you are here, you please come forward. Mr. Zunino?
Thank you, Madam President. This is the matter of Nevada State Board of Pharmacy versus Quasha Felton. At PT 26333, this is case number 22204 PTTS. The notice of intended accusation appears or begins at page 2985 of your board book. The allegations, to summarize, are that the respondent stole some cash, $320 from the pharmacy where he or she was working. The respondent's employment was terminated. That's it. There was one count alleging unprofessional conduct. Because the respondent did not appear today, you can find that the respondent essentially admits to the allegations in the accusation. But of course, we have to prove service. So the declaration appears at page 2993 of your board book. That's a declaration from Gisette Finericone again. And that details what she did to ensure that the respondent was properly served with notice of today's hearing. Exhibit 1 appears at page 2995. That's the certificate of service, indicating that the notice of hearing in this case was mailed via certified and U.S. mail to the respondent at 2 different addresses. That occurred on the 10th of June. That mailing took place on the 10th of June. Exhibit 2 again is the record of the tracking information that was assigned to each parcel. Exhibit 3 is the USPS tracking information, which shows that the parcel was delivered to the North Las Vegas address on June 16th, 2025. Of course, as indicated in the declaration, these were mailed to the last known addresses on file with the Board of Pharmacy. And then finally at page 3003, there is a memorandum of costs and fees indicating that the board staff in investigating and preparing this case for hearing incurred costs and fees in the amount of $482.27. First, I'll ask you to admit exhibits 1 through 3.
Exhibits 1 through 3 are so admitted.
Next, I'll ask you to make findings. One, that the respondent was properly served with notice of today's hearing. 2, I'd ask you to make findings of fact consistent with paragraphs 2 through 6 of the accusation. I would ask that you make conclusions of loss consistent with paragraph 7 of the accusation. I would ask that you make findings of guilt consistent with paragraphs 8 through 9 of the accusation. I would recommend that you revoke the registration retroactively to October 31st, 2024, which is the last day that this respondent actually held an active registration. And I'll just note, and I think if I don't recommend like a period of ineligibility, I think the default would be 1 year. And here I would recommend 1 year, you know, if you choose to include that, so the respondent would be ineligible to petition for reinstatement for a period of 1 year. I would recommend that you impose a fine of $500 if the respondent petitions for reinstatement. I would recommend that you impose costs and fees in the amount of $482.27 if the respondent again applies for reinstatement. And I would ask that you make a finding that the costs and fees were reasonable, necessary, and actually incurred.
Thank you.
I'll wait for the discussion.
All right, so we have a motion by Mr. Kogo. Do we have a second?
Second.
Second by Mr. Porat. Any further discussion?
I know you're picking up this, but I just think it's for that. Greg's attempting a new scenario for you, which is he's putting the payment upon, you know, request for a new license or reinstatement. And the purpose for that is, and you have to weigh how you want to do this. And ultimately, I want you to, you know what you're doing, but then we skip we're not going to go try to collect it. We're not going to, the controller doesn't do all that work. We don't have a lot of success when don't show up, that they're ever going to pay. And then we're jumping through hoops. We're putting the Treasury Department through hoops. And that may be that you want us to do all those things, but I just want to point out that Greg is clearly deferring that till they come back, and then we don't have to do the collections and all that stuff that goes on that. And you may like it. I don't know I've agreed to this, Jens agreed to this because the return on investment is low, and we're spending resources to do it, but I just want to make it clear that's why he's doing that, and Greg has added anything he wants to that.
Well, I agree with Mr. Weiss.
All right. Any further discussion?
Adam Ford for the record, I would say, Dave, yes, I did notice that change.
We couldn't, I tried to jump in the first one, it was too late. They were talking about it on the second one, I was like, I better say it on the third one, so.
And I would say in a case like this, the chances of actually getting payment are very, very slim. So I would agree that it would be a waste of resources to do it. So hence.
Back to you, board member Porat. If there's a case where you want that to happen, just tell us, and then that's the way that we're just trying to streamline ourselves all the time. So that's what we're trying to do. So.
Any further discussion? If not, all those in favor?
Aye.
Any opposed? That motion passes. Great, and we'll go to our next agenda item for 5X for Robert Hingham. We have Dr. Hingham, former representative here, please come forward. All right, I don't see anyone here. I'll turn it over to you, Mr. Zunino.
Okay, thank you. This is the matter of Nevada State Board of Pharmacy versus Robert Ingham, MD, case number 23-489 CSS. The accusation in this case begins at page 30 of your board book. Just to summarize, the accusation alleges that the respondent, a physician, held a certificate of registration during his career as a physician. He did not ever check the MyRx function on the prescription monitoring program. I think that was for at least a period of 10 years. He never checked that. He did on 2 occasions check the patient's prescription history that occurred in 2018 and 2019. However, that doesn't suffice for purposes of the prescription monitoring program statutes. Additionally, he did not, when he did check the PMP, he did not check it himself. He had like his front office staff do that. He gave his username and password to the front office staff. Ultimately, he left practice in, I think, early 2023. And thereafter, someone using his username and password issued fraudulent prescriptions under his name. And I think that could have been avoided had he not been careless with his username and password. And I think it could have been avoided if he'd set up a secondary authentication on and he simply did those things. At least those are the allegations. And so, of course, as with the other 2 cases, the board staff needs to establish that the respondent was properly served with notice of today's hearing. There is a declaration. It looks like it appears on page 3042 of your board book. That is a declaration of Aaron Miller, who you all know works in board coordination. Like the others, there are 3 exhibits appended. So the exhibit 1 is the certificate of service, indicating that the notice of hearing was mailed on June 11th, 2025 to Dr. Ingham's last known addresses, one in Las Vegas and another in Henderson. Exhibit 2 shows the USPS tracking numbers that were assigned to each of those parcels. And exhibit 3 is the USPS tracking information. And if you scroll down to page 3050, you'll see that that was delivered on June 16th to the Henderson address. Additionally, there is beginning at page 3052, a memorandum of costs indicating that the board has incurred costs of investigation and prosecution in the amount of $691.46. So with that, I would ask, Madam President, that you admit exhibits 1 through 3 into evidence.
So admitted.
And then I would ask that you make the following findings: that the respondent was properly served with notice of today's hearing. I recommend that you make findings of fact consistent with paragraphs 2 through 8 of the accusation. I would recommend that you make conclusions of law consistent with paragraphs 9 through 18 of the accusation. I would recommend that you make findings of guilt consistent with paragraphs 19 through 27 of the accusation. I would recommend for discipline that you impose, and I think this is consistent with other cases with similar facts, that you impose a public reprimand, that you impose a fine of $5,000 that would be due and payable within 30 days of today's date, that you impose costs of $691.46, and that you find those costs were reasonable, necessary, and actually incurred.
And
Question,
yeah,
does he still have an active controlled substance restriction?
He does not, no. No, he let that go. I think at the end of 2023, he gave up his practice. I think according to to some communications with him in March of 2023. The prescriptions were issued under his name some point thereafter. He did not renew his registration when it came due for renewal. I think it would have been due for renewal in November 1st of 2023.
I agree with Greg, not that that helps.
So is this one of those scenarios that if he were to reapply, then he would be required to pay the amounts for the attorney's fees and costs and the fine, et cetera? Or is this one of those where we seek?
Well, I think this is one where certainly if he came back with a petition for reinstatement or a renewal, in fact, because I'm not actually asking you to revoke his registration. But if he were to come back and try to renew his certificate of registration, he would certainly have to pay that fine. What I'm recommending that it be made due and payable within 30 days, just because of the nature of the offense, and I suspect that he's got the means to pay the fine, and so that's the basis for the recommendation.
I think the fines are consistent with what we've done in the past. Don't necessarily have issues with that.
Yeah, Adam Porth for the record. I would that we the defendant was properly noticed, that findings of fact, applicable law, and findings of guilt are consistent with as outlined by board staff, and that attorney's fees and costs were reasonable, necessary, and actually incurred in the amount outlined by board staff, and that we find Robert Ingham, MD, $5,000, and he would be responsible for the attorney's fees and costs, and that he receive a public reprimand.
Payable in 30 days.
Payable within 30 days.
Now I second.
Motion by Ms. Porath, second by Mr. Kogo. Any further discussion?
I just want to say what happened to Adam was because he asked that question instead of being able to say so move. He had to go through the whole thing again. Let that be a lesson to you.
Right.
All those in favor?
Aye.
Any opposed? And that motion passes. Thank you, Mr. Zunino. We'll move on to our next agenda item. I'll call for item 10A for Optum Care Cancer Pharmacy in Henderson. So if we have representatives, they can forward. Hi, good afternoon. Good afternoon. If I have each of you say your full name and titles for the record.
My name is Colby Meyer. I will be the PIC at attended location.
My name is Brandy D. Porter. I'm the VP of Pharmacy Operations for Optum Care Nevada. My name is Ida Bernardo. I'm currently the IV Technician and Country Manager for South.
And then I'm gonna swear each of you in, just need a verbal affirmation from each of you. All right. You swear that the testimony that you're about to provide will be both truthful and complete? Yes.
Yes.
Okay, great. And then for the record, I am familiar with Fulton Meyer from his time at Richmond University, but I feel like I'm participating fairly and unbiased in this matter. With that, I'll turn it over to Mr. Dowd.
Thank you, Madam President. This is an application that starts on page 3,331 of the board book. It's an application for a new pharmacy in Nevada. They specifically stated on the application, this would be an oncology infusion center. And they listed that they would be performing sterile compounding. So I'll just have a few questions for you related to that.
Yeah, of course.
Tell us a little bit about the Optum Care Cancer Center Pharmacy in Henderson. What's the plan for that?
So in current state, all the pharmacists function in a consultant capacity, so we're not involved in any of like the medication storage or the dispensing of the the chemos. But as we move into Optum is under construction of a new building that will be opening up. And so where our hope is to convert it into a licensed pharmacy space where the pharmacists have direct oversight over the compounding and over the sterile compounding areas and the inventory, medication inventory.
And would it be servicing patients just in that particular infusion center?
Yes.
And would it be all immediate use sterile compounding, meaning that it would be administered within 4 hours of compounding the medication, or would it be dispensed to patients to take home with them?
So it would be for immediate use compounding, but it will be inside of a clean room and inside of the proper PECs.
And what type of products will you be compounding there?
Hazardous and non-hazardous.
Anti-neoplastics, I'm assuming?
Yes.
Okay, great. Colby, can you give us what your experience is as it relates to hazardous sterile compounding?
So hazardous specifically, I don't have a lot of experience directly in there, but I do have experience in non-hazardous compounding related to USB 797 at a different hospital previously.
Why don't you just talk about that experience first then?
Okay, I was clinical pharmacy manager at Kindred Hospital for approximately 3 years. And so there I kind of oversaw the clean room and everything related to that, the compounding there.
And are you familiar with the revised USP 797 guidelines that went into effect from an inspection standpoint earlier this year?
Loosely familiar with it. I have reviewed them and yes, I'm familiar that there are revised guidance there.
And who will support you in obtaining the knowledge related to that?
I will be. I'm currently the designated person for the SBA.
At this location?
Will be in the future. Currently, I'm a contractor. We're trying to still figure out the organizational structure.
Okay, great. And why don't you then explain what your background is as it specifically relates to USB 800?
Currently my role as the infusion technician, so we mainly compound like sterile compounding, mainly focusing on USP 797. So we also have hazardous compounding at our current location. So I've been at the company for 10 years. I've been pretty much just infusion technician for roughly almost 15 years now. That's all right now. And like all compounding related items. So currently I am very familiar with the USB 797 and 800 also that's taking effect this year. I have a staff of like less than 10 people currently that's compounding, but we are making sure that we are always going to be in compliance and we have all the documentation that supports that as well. So I am.
And when you say current location, is that a current Optum location?
Yes, sorry, Southwest Medical Pharmacy, which is part of Optum Care.
So it's not at a cancer center, it's at the home infusion location,
Yes,
correct? Okay, and do you do hazardous sterile compounding at the home infusion location?
We went live like last year because we did a construction for our negative pressure room. We pretty much built a whole new clean room, which I'm pretty sure, I don't know if you remember, but we built a whole new room for it. So to make sure we're in compliance, but we're waiting for orders to come in, but we're actively practicing to make sure that we're in compliance as far as like regulations, how to gowning and garbing and all that.
And you will be physically moving to the new location then if it's approved?
We're still working on the organizational structure, so we've been consulting with EDA on the construction of it in addition to our real estate services, but from an operational standpoint, consulting with EDA for that.
And Ida, you will be the designated person at the new location if it moves forward with that?
So right now, the construction is tentatively scheduled to be completed in January. So we had a designated person that has moved on, and so we're working on that organizational structure to have the designated person, but we are aware that we have to have a designated person for that space.
And Colby will not be that person as the PIC, or you're still determining who's going to be the designated person?
So I will definitely be kind of like the stand-in person. And I will be that person if we don't find like a better candidate to replace me. But yes, I will be that person until we find someone else.
And if you're not the designated person, I'm assuming it's a fairly small location from a pharmacy perspective. What would your role be if you're not the designated person at the location?
So currently, I work in like as a consultant doing a lot of the clinical workups of the cancer patients. And so that will continue to be like my goal is to be like the clinical side of it instead of the operational side of it. But I will be the pharmacist in charge there definitely, but we will hopefully have like a hazardous operations pharmacist to manage the IV rooms.
And you will physically be located at the facility?
Yes.
Great. Have you invested in any training specifically related to USP 800 at this point? Any three of you?
I know we have a lot of like company learning programs that I've gone through and I've done like self-study on it as well. If that answers.
We also all have read USP 800. We also follow Contact has some live training as well for the staff. And we've also created training as far as like how to use our CSTD widget for all the staff members, as well as like just following guidelines on how to properly guard PPE and just making sure ensuring safety for everybody else. But again, at this time, we have not been able to compound yet for hazardous, but we are ready. We're ensuring that everybody's passed the media film and also all the other competency assessment that is USB 800 to make sure that we understand the concept and the dangers of it.
Okay, and has construction been completed at the facility for the USP 800 room?
No, not yet. So tentatively scheduled for January. They're expected beginning of January. We're probably anticipating end of January, so we would be ready for pre-inspection early to late February.
Okay, and you understand obviously all of the guidelines specifically related to USP 800 and the construction of the facility?
Absolutely, yes.
Will you use the same construction company that you use for your location that you're working at right now?
Yeah, so we had we had the same project manager who has moved on, but it's the same real estate services. And they've built out multiple clean rooms. They have the externally vented hazardous pressure room, negative pressure storage space as well for our ADS machines.
And it looks like you'll be doing some non-hazardous sterile compounding as well at the facility. Will you have then two separate buffer rooms?
Yes, not the two separate anti rooms, but the two separate
buffer rooms, but shares an anti room.
Yeah, shares an anti room. Yes.
Makes sense. Great. And who will actually who will be performing the actual compounding at the location? Will it be technicians, pharmacists, both?
Technicians for the most part.
And who will train the technicians?
I personally train the technicians and also depending on who, like the pharmacist as well. But mainly it will be the technicians. It will just follow what our current processes are.
Okay, and obviously you're familiar with all the requirements as the designated person at a facility. A lot of responsibility.
Our current location did also go through ACHC accreditation for the USP 800 space as well. And the designated person, we do look at the ASHP training program that they have also. That would be our ideal candidate that's on that, or we would support that training also.
And just the last question, I'm just interested, why did you decide to actually have an on-site pharmacy at this location versus the normal procedure that we see at oncology offices?
Yeah, so most of the time, like as you guys know, most of the oncology locations do physician dispensing, and a lot of the literature and data supports that the more pharmacists are involved in that compounding and oversight process, better outcomes for the patients. And so we kind of wanted to make a push for it because our hands are currently tied as consultants as far as like that oversight. So we're trying to do things the right way and the correct way. So
great, makes sense to me.
Safety front of mind.
Of course, great. Thank you. No more further questions for me.
In reviewing the application, Mr. Meyer, your employment history, it ends in 2023. Have you been working as a pharmacist since 2023?
Yes, and so I think in the application, I think I needed to like document X number of hours for it, and so I just showed probably the most applicable hours for the application. But I started with Optum January of 2024, and I merged those two jobs. I worked at Sunrise Hospital for 3 or 4 years as well in addition.
And then for board staff, for the designated person, do we need an application for the designated person?
I can answer that question. It's not required for the designated person. They just have to make sure that that information is available upon inspection.
And I think that the only, and I'll just say it ahead of time, yeah, I'll go ahead and say that at the end. It sounds like a solid structure. It sounds like you're in the middle of figuring out things, and that's okay with the board. The inspection addresses what's really happening. I think that we've seen challenges. It's great, the technician's great. You have a great knowledge. We've seen challenges where that outpaces the pharmacist, and then is the pharmacist actually. I think I broke the image. Did we lose Zoom? Okay, well, I'll just hold that thought.
We're gonna blame it on Jody, Dave.
Oh, we just lost. So anyway, I think everything you're doing is great. Just remember that the pharmacist is ultimately responsible. I think that's what the board's probably gonna tell you, so I'll just jump out. You can reinforce that.
I think you covered it. That was one of our, the thoughts that came to mind. I think Ms. Bernardo has a lot of experience and we appreciate that. And then with Mr. Meyer being the pharmacist in charge, ultimately that responsibility lies heavily on you. And so I want to make sure that you have the skill sets to oversee and properly manage. And so I think Mr. Weist brought out that point and a concern for us.
Yeah, Adam, for the record, I would echo that concern. I mean, I think that we have an opportunity, given that the construction is going to be until January, that there's adequate time that you could get some additional training specific to USB 800. And so I would recommend that be a condition of approving the application, that in addition to receiving a favorable inspection, that Colby provides evidence that he's had some training specifically to USB 800 in the amount of, I don't know how many Cs we want to put to that, but I would say at least 2 hours.
Yeah, sounds fair.
I would agree, just because in case they don't find anybody to be their designated person, he would have to step in.
Right, and ultimately, as was outlined by board staff, I mean, it's your responsibility to oversee the technician's work, and so it's imperative that you have independent training of what's being provided by the technicians, because you could be trained wrong potentially. And so, you need to be the one that's responsible for saying, no, it needs to be done a different way. So I think some independent education there would be useful.
That'll set you up for that. Any other questions?
Just one point of that. So whoever is the manager will pick that up on inspection then. So if it's not, because it may not be him for some reason, we don't know. You're requiring 2 hours for whoever the manager is, they have continuing education, but like. And we'll pick that up during the section.
We'll be rooting for Chloe, but yes.
Yeah.
I know, I'm reading.
We know that you're very competent. There are technicians that are in the training world, it's just, I think Adam said, it. You need to see multiple views so you can say, "Oh, I found the right view," so that's.
Adam Porth for the record. So then I would move that we approve the new pharmacy application for Optum Care Cancer Pharmacy in Henderson, pending favorable inspection and proof of 2 hours of continuing education for the pharmacist in charge.
Crystal Freitas, second. We have a motion by Mr. Pora, a second by Ms. Freitas. Any further discussion? All those in favor? Aye. Any opposed? The motion has passed. We thank you for your time and wish you all the best for pharmacy. Thank you.
Thank you.
We will go next to agenda item 6A for Bespoke Pharmaceutical LLC. We have representatives, please come forward. Hi, good afternoon.
You're talking to me, right?
Yes, talking to you.
How are you, Ms. Park?
I am good. Good to see you. Could you, if you could state your full name for the record?
Eric Sparks.
And then, will there be anyone else joining you today?
Currently, no, it's only if needed.
Okay. All right, and then just to disclose for the record, I am William Mr. Sparks from this time at Coastal University, but I feel like I participate fairly in this matter. That, I'll turn it over to Mr. Dodge.
Thank you, Madam President. This application starts on page 3070 of the board book. This is for Bespoke Pharmaceuticals, and it's an application for a new manufacturer in Nevada. You may recognize Mr. Sparks. He was recently at a board meeting for Bespoke Pharmaceuticals on a pharmacy application. So this is for a manufacturer application. I'll disclose that Crystal and I went to visit the pharmacy location for a pre-inspection in early June and met with Mr. Sparks at that time, and we were able to tour the facility. So Crystal and I have a little bit of inside information as to what the facility currently looks like right now. So Mr. Sparks, can you just kind of talk about the logistics and what the plan is for the location? Because it's just fairly unusual for a 503A pharmacy and a manufacturer to be in the same facility.
Understood. Thanks, Joe. The current plan is to only have the 503A portion open for about a year. Then it'll just be dispensing whatever is coming from the other side. However, the plan right now for the manufacturing portion is to be a CDMO. And that will be strictly right now for packaging. So no drugs for a while. So the minute we're able to have drugs, it'll be similar to your outfit of a B selling drugs to their A, or ATA, whatever you want to call it for dispensing. But that'll be down the road.
Can you define what a CDMO is?
Contract manufacturer.
And at the location, you're listed as the facility manager for the manufacturing location, is that correct?
As you know, I am the most responsible person. Yes, that is correct. As far as title wise, that's yet to be assigned. I was told at some point I'd have a leadership position in that side. But I will be the most responsible person on that side.
And as the facility manager, what will your responsibilities be at the manufacturing location?
I will be knowing the ins and outs of everything as I usually do. And coordinating all aspects of the business. I don't know whether or not I will be currently on production side or quality, but it looks like I'll probably end up on quality side again. Enforcing the regulations and ensuring everything is done properly.
And what's the current status with the FDA as it relates to the manufacturing?
As far as I'm aware, they applied for the FDA registration number. I don't know if it's been assigned yet.
But it's a requirement for you to be registered with the
Yeah,
FDA,
yes,
correct?
mhm.
Okay. And is the intent to be a 503B outsourcing facility in the future as well at the
Yeah,
location?
yes, sir, that is the intent as well. I had brought that up as to why the application was completed at the inspection for that might occur after the year deadline for inspection.
So at this point, you don't have any specific plans as to what potential drugs may be manufactured at the
I'm not
location?
sure at one point there was, but now it's strictly packaging.
And for the 503A pharmacy that has been approved for pre-licensure, you had sent me an email about some of the drugs that you may be compounding there. Can you just mention to the board what those drugs would be?
Yes, sir, the current drug list, and I'm about to send you some more, could be methylcobalamin, sermorelin, and NAD plus are the current ones in formulation. Right now, we're at the lab undergoing testing.
Okay, but those would not be transferred to the manufacturing.
No, sir, as far as a 503B, you are allowed to do sermorelin acetate, which is on list one. Methylcobalamin, I believe, is also on list one. NAD and not the oxidized form is on list one, so that'll be another discussion, but yeah. Absolutely.
Okay, and as I mentioned, Crystal and I got to visit the facility, and it appears that you have a lot of the equipment already in place for the manufacturing. If you can just kind of walk the board through what type of equipment you have ready to go, whether it's going to be fully automated, what the plan is for the manufacturing.
Yeah, it's basically a fully automated facility from top to bottom, and you only need somebody to put a tray in the tray. Let's say it's 96 vials or 100 syringes, and the robot will open up the tray, it'll go through. It'll fill it, robotic everywhere. As far as the packaging is concerned, it'll make a box, it'll glue the box, it'll put the insert in the box, it'll put the drug in the box, the package insert in the box, it'll seal it, it'll wrap it, it'll serialize it and drop it onto a pallet.
And the equipment's already been purchased and is currently in place, correct?
It's been validated.
Who validates the equipment?
So we had Corber out there, an engineer from Corber that was strictly involved, and they had show companies come out. Sure.
And you have to submit that to the FDA, so they would have to approve the validation?
Typically, they come and check it on inspection.
And Corber are they the manufacturer of the equipment that you're going to be utilizing?
Yeah, they bought out Dividella, and Dividella is one of the machines. Yes, that's correct.
And what's the proposed staffing model for the manufacturer, if you've got to that point yet?
We need about the whole thing, maybe 10 operators. It just depends how you're running it. There's not a need for a lot of people when it's fully automated.
And will the operators be pharmacy staff members? Will it be pharmacy technicians?
Yes, so currently we're trying to hire pharmacy technicians, actual knowledgeable pharmacy technicians, so they can get employed and work on that side. But if I need help at some point in this current A until that gets switched out, they can come and assist. That is the plan. So yes, there will be multiple technicians. There already is on site. Maybe 6 technicians on site already.
And do you have a quality manager?
Yes, we do.
And what's their position as far as?
He's the Director of Regulatory Affairs, and Quality oversees everything. That's correct.
And what's his background related to manufacturing?
He's a manufacturer for sure.
So he worked at the FDA or he
No,
worked
no, he worked in manufacturing.
at an FDA approved facility?
Yes, sir.
Okay, and is he already on site at the facility?
Yes, every day.
Okay. How many staff members do you currently have working at the location for the manufacturing side?
I would roundabout guess about 14 maybe.
Okay, and what's your intended date of opening if your application is approved? Have you guys got to that?
Well, we have a year. I believe it's September, October at this time, but as you know, these things are slow and there's always hiccups along the way. So it could be a little bit longer than that, but that's what the outline is right now.
And obviously with 503Bs, you can start producing product before the FDA performs an inspection. Is it the same process for manufacturers where you could
No,
start?
I believe you gotta do it in advance.
So you wouldn't be able to open until the FDA performed an
Yes,
inspection?
sir.
Great, excellent.
I was gonna ask, I don't think that's necessarily true, but it doesn't matter for this, but there's a possibility that they could operate. I've seen it done, so
Well, let's go then, Dave.
But just for the record, you've filled out the paperwork, you've registered, you've begun the process of registering with the FDA?
Yes, sir.
Okay, that's the.
Also, the application is for the Department of Health. We already paid the fee. Teresa Hayes is no longer involved, so I'm talking to Mark Potts now. I don't know the status application at this time.
And who will you be selling the products to from the manufacturer?
Oh, well, when we get to that point, directly to the customer. Which is the physician,
Okay, so practitioners.
you know.
Okay. And just one final question for you. You may or may not be aware of this, but I know Leo's listening. There's a marketing code of conduct that's required for manufacturers. So you want to make sure that you're familiar with that process and we'll help you through the process as you
Please
go.
send
along.
it to me. I'll make
Absolutely.
sure it's done. Thank you.
Yeah, if you're doing that, you might as well talk about the DQSA too. So like, we need to be tracking these drugs. So you're ready for, yeah, 3D tracking and all that stuff.
Okay.
No further questions from me at this time.
All right, board members, any additional questions for Mr. Sparks?
I don't have any questions, but I would just comment on the tour. It was very interesting to see a manufacturing facility set up in Nevada. So it was just something that I wanted to experience and see for myself, but so it was very interesting, and Mr. Sparks is very knowledgeable, so.
Very good. Are we ready for a motion?
I move that we approve application for new manufacturer for Bespoke Pharmaceuticals.
We have a motion by Mr. Kogo, a second by Mr. Porath. Any further discussion? All those in favor?
Aye.
Any opposed? That motion passes. Thank you.
Thank you very much.
Appreciate your time.
Thank you.
Your time too. Thank you.
I might recommend a break. We can let Todd take off if he wants, or you can stay.
We'll take a quick break. All right, we'll continue with our agenda at 16:08 for Larissa Smith. So Larissa Smith, if you are here or online, please raise your hand or come forward. Press *9 to have your line unmuted.
She's online, but she's not.
So she's scheduled for tomorrow, non-disciplined. She's online and we're gonna get her unmuted, but we're talking to an eye right now. Larissa,
Yes.
you there?
Yes,
Okay, thanks.
Okay, great. All right, so if you could please state your full name for the record.
Larissa Lee Smith.
Okay, Ms. Smith, I'm gonna swear you in. If you can join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes,
Great, thank you. All right, Mr. Weist.
Thank you, Madam President. Board members, in front of you is an application for tech in training. I will commend both Dick Tomaso, Yen Long, Dr. Yen Long's electrified warning, because it does seem to be working. So Larissa made some disclosures on the tech and training application. It starts in the board book at 3866. But the disclosures are on 3867. So Larissa, you're trying to become a tech and training, is that right?
yes, sir.
Are you working in some place that has a pharmacy now, or you're looking for a new profession, or what are you doing?
I'm currently working at the store, Walgreens, and I'm being transferred to the pharmacy portion of Walgreens.
Great, okay, so they said you gotta get this license in order to work back in the pharmacy?
Correct.
Okay, and then so you've made several disclosures, most of which don't really relate to anything that the board would be concerned about. But there is a February 2016 that will roll into 17 event related to possession of a drug. So what was it? Can you explain to the board what happened in that scenario and what happened with law enforcement?
Yes, I was back then, I was in a bad place. I was I was a user at that point. I was
Of
found to
what?
have,
Of what? What were you using?
methamphetamines.
Okay.
and I was found in possession with methamphetamines, which caused me to have a case. The incident actually happened in 2015, but I wasn't seen by a judge until 2016.
Okay, and so was it alcohol too and other substances or just methamphetamine?
Just methamphetamines.
And you were buying that on the street?
I had possession of it, yes.
And were you smoking it or how were you ingesting it?
I was smoking it.
Okay, and so, you're gonna go in a pharmacy and that's good, this is gonna be something we need to protect you and the public from. The
Correct.
board does give second chances, but we'll see what they do with you today, but like, how would you describe what's changing your life that we can be assured that the access you have to methamphetamine and other drugs, you will not abuse that privilege?
I've been 9 years sober, with no setbacks, no relapses. I have I have a family that loves and supports me, and I also have not associated with my prior associates in about 9 years.
When was the last time you took illicit drugs?
It's been about 9 years ago.
Okay, and are you in a program or anything, or you're on your own now and you did all that and you've passed that stuff, or where are you in your sobriety?
Correct. I was in a program for 60 days, which got me off of the narcotics. I kept that up for the 9 years. I go to meetings regularly. I also attend family counseling and individual counseling still on a regular basis.
Yeah, and when was the last time you were evaluated back for the 60-day thing?
I've been evaluated. I'm evaluated pretty often. No, not drug tests or what have you, but as far as my therapist is concerned, I've been evaluated on a regular basis.
Great, that's good, that's good. Your therapist is a doctor or an APRN, or what, do you know what their credentials are?
Yes, it's a substance abuse counselor.
Board certified, okay, sounds good. I don't have any other questions, I kind of laid it out in front of you, you can figure out which path you're going to take. Thank you, the board will ask some questions too.
Okay.
My name is Helen Park, just have a couple questions for you. So in the beginning, you mentioned that you need to obtain this license for your employment at Walgreens. So is this something that, like, do you want to work as a pharmacy technician, or is it more of a requirement of employment and something that you're being asked to do?
Muted, she got muted so whole time. You're unmuted now. Did
I'm
you hear the
sorry.
question? Did you hear the question?
Yes, I want to work as a pharmacy technician now.
Okay. And then what interested you in doing this type of work?
Previous to this, I was a manager at several convenience stores. Terrible, Chevron being one that I have been with for about 4 years. 7-Eleven, I was with it for 3 years, and now I'm at Walgreens. It basically interests me because I wanted to, I've always wanted to be in the medical field, and this, enter into the medical field of some sort.
Okay, and you've had a history of substance use disorder, but you
Yes.
mentioned 9 years of sobriety, which is great. You also mentioned that you have not had any relapses since then. What do you think is the main contributor, or what factors have led you to be successful in your sobriety?
Basically my constant attendance to AA meetings and NA meetings. Also, my family has been very supportive. I have a great husband and great children. I've had constant people that have kept me you know I mean, not obligated, but they've kept me consistent on, things that they see might be going wrong. I currently take depression as well as anxiety medication and bipolar medication that keeps me level headed. I don't miss my doses. I don't go off the rails. They've kept me accountable for my actions. And that's been something that's really helped me in the past 9 years.
That's great. And then for your AA and NA meetings, is that something that you think you'll continue moving forward?
Yes.
Okay. And then the regular meetings and the evaluation from mental health, is that, or with your therapist, are those required or something that you choose to do?
Something I choose to do.
Great. And then with the offenses that happened in your past, did those happen in Nevada or were those out of state?
In Nevada.
Okay. And then, but at this point in time, you do not associate with any of those individuals that you previously associated with?
Correct.
All right. I don't have any additional questions. Board members?
I just have a couple of questions. Ms. Smith, how long have you worked at Walgreens?
I've worked at Walgreens for about 5 months now.
And before that, you were at Terrible's?
Yes, I was a manager at Terrible's.
And what do you do at Walgreens?
At Walgreens currently, I'm a cashier as well as stocking and things like that.
Do you have any problems at all with alcohol?
No.
Thank you.
Any other questions, board members? So, not necessarily a question, but so it sounds like she is seeing substance abuse counselor. I would want an evaluation. How would that work with her current situation?
I mean, you guys, you know this, but I'm just gonna go through it. So we have a standardized PRN like program, which various people that are certified by the alcohol board may or may not qualify. They have to kind of have 2 qualifications. An MD qualifies, that's why I asked that, focuses on that, or a nurse practitioner, or PA that focuses on that will qualify. So it would be impossible for me to determine that today. So that person may qualify, and then we can just get that, then she would just do that. Or if you're going to put that recommendation in, then it would be somebody else that would qualify. She gets to choose who that is. So she has multiple paths. If you just say it has to be that, board staff will vet the person that we might know of or we may not or whatever, and we'll go through that process. So if that, just say an evaluation by PRN like, and we'll send her the instructions for that and work through that.
I just wanted to confirm the evaluation would include perhaps a drug test.
The evaluation does not include a drug test. The evaluation is a risk for her placement into a pharmacy. It sometimes comes with recommendations, and then you can put that as a condition of her license. So many times you'll say, you already know this, but a positive evaluation, but no, they won't do a drug test. If that's something that you want, then that can be added in it, but that is generally, for the most part, the people that do it right are doing it in person because there's markers that they need to look for as they're doing it. So it's generally an in-person evaluation. discussion.
Discussion. Ms. Smith admitted to, but said that she takes medication for depression and bipolar. Wouldn't that affect you as a pharmacist? You would know that. Would that affect the a drug test or anything? Would that?
They screen for certain drugs on the drug test, so we're looking more for like illicit drugs.
Okay, well, how about the fact that she does take that, and are we gambling if she stopped taking the medicine, that she would go the other way and in a pharmacy? And would that affect her if she stopped taking that medication? I'm just wondering.
Looking for the drug test, you did?
No, not for the drug test,
I
for
think-
her own actions.
I think it could affect someone's behavior, but that would apply to many individuals. So I think there are many people out there that are on those types of medications. It is their responsibility to maintain their health, and then if they are unable to maintain their health, it is their responsibility to kind of disclose that, but I think that just,
That should be.
that shouldn't be. Yes.
Can I ask her a question?
Certainly.
Mr. Adam Porth, for the record, I'm assuming that you were drug tested 5 months ago when you started your employment at Walgreens?
Correct.
Yeah, thank you. I mean, I commend her for 9 years of sobriety. I think that she is doing all of the right things that we would expect someone to do in maintaining their sobriety. It sounds like she has a good support system. So I mean, I think if the rest of the board feels like we need to have a PRN or PRN-like evaluation, I'm fine with that. But I feel like she's answered all of the questions that we would typically ask. And we should be giving people a second chance.
I agree, we should be giving people a second chance, but that doesn't mean we shouldn't take the necessary steps in order to protect their safety and the public safety. And when they're doing the drug test for like retail level versus in the pharmacy, I know the drug test can differ as far as the quantity of drugs they're testing for and the types of drugs.
Yeah, and I do think that Ms. Smith has made a lot of changes that are a lot I think that are positive, but I would feel more comfortable with a PRN or PR like evaluation to confirm that. And I don't see any harm in requesting a drug screen, an additional drug screen. And then I think that sets her up and gives her another opportunity.
When you're going down that path, I think what would be best is Greg will pay attention to what conditions you put on it, and then we'll send her an official, which we do, we'll take an official letter to her. These are what the conditions are in order to get her license. So just giving Greg a heads up.
Doesn't have to be part of the motion?
You'll do the motion, but he'll take notes, and then we'll make sure we're doing we have a newer program where wherever they are, they're getting notice from us of what happened at the board meeting, so they have clear direction on which way they go. And the drug test is definitely doable. I can see some roadblocks and some easy paths, so we'll just see where we are. The roadblock, I just put it out there. If you require that, somebody's gonna have to do it. We're not in a position to administer that and track and do the, the security of it. We would have to, she'll have to go get that, and then we'll have to review it. It would be nice if that person that she already sees meets the qualification and they can just add it on during a normal visit. Whatever you decide to do, we'll do. We just need to make sure we're clear to her what she has to do.
So I would move that we approve application for tech and training for Miss Larissa Smith pending a favorable evaluation by PRN or something similar to that program. And also a drug screen.
So we have a motion by Mr. Cobo, a second by Mr. Tomaso. Any further discussion? Hearing none, all those in favor?
Aye.
Any opposed? Okay, that motion passes. So Ms. Smith, your application has been preliminarily approved. There are some conditions that you have to meet, and board staff will communicate those to you.
Okay, Perfect.
We wish you all the best.
Thank you.
Thank you. All right, next we'll go to 15A for Trina Colby. So Trina Colby, if you are here or online, if you have, raise your hand or come forward.
Hello, I'm here.
Hi.
Hi,
If I could have you state your full name for the record.
Trina Hollingshead Colby.
Okay, and Ms. Colby, I'm gonna swear you in. If you could join me in raising your right hand. Do you swear that the testimony that you're about to provide will be both truthful and complete?
Yes.
Okay, great, thank you. All right, Mr. Weist.
And I apologize, I'm in my car. I took yesterday off and so I'm at work, so I ran out to my car, so.
Well, hopefully you'll get through this and you'll be able to move on with the rest of your
You're
life.
not driving, right?
No, I'm in the parking lot. But you may hear the air conditioner because it's really warm out.
Trina, at this stage, when you on the executive board pharmacy, I'm just gonna ask you some questions.
Okay.
I think from board staff's perspective, we're not too concerned about it, but I always go back to what Mr. Tomaso says, that there's certain times you just gotta get people under oath and ask them the questions, and then you make your determination. So this is the case. So I think in your past, and again, in the electrified warning seems to be working, you've disclosed, and I'm just confirming it that I know what I'm talking about, is some form of driving under the influence, and the influence was alcohol. Is that correct?
Yes, it was a wet and reckless.
Okay, got it. Whatever it was that, they always figure out where they're gonna go. And then I think what became concerning that we needed you to explain to us, but it may be a very simple explanation, is then you got in trouble with California because you didn't understand the requirement of reporting. And so then you got put into that washing machine of, you didn't report it, and then they took an action against you, correct?
Correct.
And then they took your license away, or it looks like.
I surrendered it.
Okay, so you were not working in California at the time, and you just why did you surrender it, I should say?
Actually, I surrendered it. My lawyer and I went back and forth, and I agreed I needed some sort of punishment. And we went back and forth, and the main reason I did surrender it is because they wanted me for 5 years and I travel. I'm a travel tech for the pharmacy that I work for. I'm actually a trainer. So I don't do many tech duties. I train on our computer system and how our system works. But I like to have the license in that state if I'm going to go to it. But they were
mandated by law, but yes, go ahead.
Yeah. And they had wanted me to 5 years every single day call in, whether I was traveling or not, and see if it was a drug test day. And if it was, then I would have to go drug test, which I didn't mind that part. My lawyer and we asked for 3 years, and they were dead set on 5 years. And it was just going to be really hard with my employer to do that for that long of a time. And I had to give them a week's notice when I was going to travel. Well, there's some days I get told the day before that I'm going to travel the next day.
Okay, yeah, I understand. So that you just made the business decision to give it up. It wasn't really related to any action that they were taking necessarily.
No.
All right, you're licensed in New Hampshire, Maine, and New Mexico now?
Correct. And I've had my PTCB since 2000.
Yeah, that doesn't do you any good here.
Okay.
Then, where are you practicing today? Or are you?
I live in California, and I do train here in California.
Okay. Okay. And so why are you looking for a Nevada license then?
My district actually just picked up our pharmacy in Reno and Las Vegas. So there's a possibility that if they ever need help because of PTO or FMLA, there may be a week out of the year I may go and help them if I have my license.
Okay. I don't have any other questions. Bunch of things with what's happening in California, but it doesn't relate to us, so I'll turn it back over to support. That's
okay.
So
hold tight.
Ms. Colby, question I had is you You got into some issues with the California board because you did not disclose your, the wet and reckless. Why didn't you
Correct.
disclose that?
I was confused. I didn't realize a wet and reckless could be considered a DUI. Because through our court systems, it was considered, it was always labeled as a wet and reckless, and it was dealt with separately than a DUI. So in the courts, it's like two different things. So I was under, I didn't understand.
Okay. And then, since then, did that occur in 2021? Or what year did that occur in?
I'm sorry, I didn't hear what you said.
Your wet and reckless, what year did that occur in?
Oh God, that was during COVID.
2023.
Yes.
21.
Oh wait, actually it happened prior to that. 2023 is when the action finally took effect.
Okay. And then, do you have any current issues with alcohol use disorder?
No. I actually, with the Board of New Mexico, I actually did an interview with one of their physicians and did their blood tests and all that.
Okay, so, have you gone to any treatment or do you do any, meetings or anything?
Actually, yes, I have a friend who owns a treatment program for alcoholism. And so I go in and I help do some of their meetings. And I sit in on their meetings, and anybody who has questions or anything like that, I'll talk with them.
And have you had any issues since 2021 with alcohol or any other substances?
No, not at all. That one incident was, it was during COVID, and I know it's not an excuse, but I ended up, I had COPD, and so the doctor took me off work, and I worked for the VA, and so I ended up having to resign. And at that time, the federal employees were not eligible for unemployment or any of the subsidiaries that we're getting. So I just had a meltdown one day at my friend's house, and
Okay. All right, board members, any questions, additional questions for Ms. Colby?
I'll make a motion that we approve her application for tech
And training.
and training.
Is it?
Or is it tech?
Oh, I'm sorry.
Yeah.
It's been a long.
I second.
All right, so we have a motion by Mr. Tomaso, a second by Mr. Porath. Any further discussion? Okay, hearing none, all those in favor?
Aye.
Any opposed? Okay, that motion passes. Your application has been approved. We wish you all the best.
thank you so much for your time.
Thank you.
And I think Brent wants to make a proclamation of some sort, might not be the right word.
Yes.
The agenda item.
Mr. Camp, so for agenda item 5, for Melissa Gauda.
Just Brett Camp for the record, this is case 24-141-RPH-S. And I just wanted to note for the record that Ms. Gauda had did subsequently make payment of the citation and fine that was assessed against her, the non-payment of which had led to the basis of the filing of charges. And so now that she's in compliance, I'm just dismissing that case on the record. Thank you.
All right. Great. I think we got all of our agenda items for today.
Yeah, I'll do my report and Greg, so we'll be done with that, if that's okay. So I'll go first and get Greg to brace himself for yours. There's no fiscal report this meeting because we're closing the end of the year for the state fiscal year, so we'll have that. We're in it. I know I've talked to Adam a couple of times about fiscal things, so we're still doing fiscal things, but there'll be no report.
We're hearing some noise from the audience. If we could ask you to keep it down. Thank you. Right, Mr. Waste?
So next meeting, you'll see the close of the year and we'll review that. Temporary licenses are on the board, change of addresses are on the board, as you mandate, meetings with other healthcare, regulatory boards. That's happening. Unfortunately, a lot of it's around, unlicensed activity with drugs, a lot related to peptides, GLP-1s. And so there's just, too much of that right now. I think all of our partners are aware of it. We're working through it. We've working with the health department, with the health department about if, do we need to be doing some public service announcements about it and things that they're really good about. So we'll be doing, I think, are there, full transparency, are there law changes that need to go in place? I mean, we have the laws in place. I think we do. The health department right now is doing an evaluation of all the states and, how the laws, we have a lot of laws on the books. If they'll follow them, then that's a problem. You guys see that every day. So I think we're doing that with that. Some work with the Southern Nevada Health District on a couple other things too. So we'll give them some credit for that. Licensing activity report citations are there. Legislative update. My goal is to have Mike Hillary do a presentation at the next board meeting. So that give me a follow-up from the legislature, and we'll do that. It looks like there'll probably be a special session. We think right now maybe in October. I don't think there'll be anything related to us, but if there's anything that we need to do, we'll deal with that. I'm gonna probably remove the Nevada law examination. I think that's been a success. There's no negative feedback. I'm sure if there was, you guys would have it and tell me. So I think everybody likes that procedure. So we're moving along on that. And then the last thing, I don't normally do this, but I would like to say, I just want to recognize that Con Pham passed away. She's a pharmacist that really helps the homeless clinic, homeless population, did a lot with diabetes. I was with her when she would go to where the homeless encampments and talk to people and try to help them with the drugs. She's unfortunately passed away. So with that, I'll turn it back over to you.
Mr. Mason, take your report. Take condolences to Papa's family. With that, I will turn it over to Mr. Zunino for a general counsel report.
Honestly, there's not a whole lot going on, at least not in the courts. I know that Brett has a case in the Las Vegas District Court, and I'll let him tell you a little bit more about that. Mr. Aguirre is representing the petitioner in that case, Festus Abanca. The other case is, and I've mentioned this, quite a few times in the last several months. It's a case that's on appeal to the Nevada Court of Appeals. And we've briefed it, and we're just waiting for the respondent or the appellant in this case to file his reply brief. And then I think the Court of Appeals might order us to appear for oral argument. I think the issues are potentially interesting. There's some kind of evidentiary issues. Like I said, I think we have a very, very strong case. I think we did a very good job with the brief, but we could end up having an oral argument on that. And if we do, I will certainly tell you and give you the time and place, and you can tune into that. And then I'll just mention, I think of course you know this, but Laura Tucker, she's out with a back injury, but I think she'll be back. She's gotten a good prognosis, and she is really enjoying her work at the Board of Pharmacy. So you'll see her in September.
You're out there. I hope you are feeling better.
She's listening.
Thank you for your report. Mr. Cant, did you want to add anything?
We do have the pending petition for judicial review here in the Judicial District Court regarding Mr. Abanca, and I'll be filing a responsive brief in that in about the next 3 weeks, and keep you apprised. We don't have a hearing date set yet for oral argument.
Great, thank you.
I don't want to argue with Greg, but I do like doing this. I don't know if she's enjoying her job or not. Good, great. So I think she's, but it's just a joke for Laura.
We enjoyed that. So, with that, the board will open up the floor for any public comment. If there's anyone in the room who wishes to make a public comment, or if there is anyone online who wishes to make a public comment, please feel free to come forward now or raise your hand. Or let us know through the chat function.
Don't see anyone, Madam President.
Right, and I don't see anyone in the room coming forward, so with that, we'll close the hearing for public.
Oh, hold on, not. Laura just texted me, she's enjoying her job.
Oh, very good.
That's for the cover.
So that completes our items for today. Our meeting will reconvene tomorrow at 9 AM. And for now, our meeting is adjourned. Thank you.